Hmm. Well, I had mentioned this matter on Friday regarding contempt pending before the your lordship had allowed this mentioning, but for some reason could not come up. The matter is fixed tomorrow.
Have you informed the other side?
Yes, yes, but notices are enclosed. WPCT. What a WPST 33. What a WPCT. List আছে?
No, ST.
That is ST.
It is not on the list.
No, no, no.
Then tomorrow morning.
Tomorrow? Yes, yes. Great.
Your Lordship, may I be allowed to mention? I had mentioned it on Friday. It's a contempt matter against the defense personnel.
Yes.
And Your Lordship had allowed the mentioning, but it has not come up. It's item number 116, Your Lordship.
Why
Today,
matters are not on the list. 160, it should be upgraded. Tomorrow morning we'll take it up.
Your Lordship, today the contempt has been fixed. The tribunal had fixed it on Monday when we informed the matter is running in the list. They again fixed it for Wednesday. As the tribunal tenure is expiring in first week of March, as a result of which all contempt matters have been.
So there must be a private respondent in this.
I have informed them. I'm mentioning upon notice, Your Lordship. So tomorrow, let it be appear as to be mentioned. I'll inform the tribunal as well.
Yes.
Much obliged.
To be mentioned. Yes. To be mentioned.
Your Lordship, item number 126. In fact, with consent of learned DSG and with the approval of Your Lordship, the date was fixed for 25th for hearing. And I'm coming from Ranchi. It is item number 126.
It was fixed for 25th.
Yes, Your Lordship.
But the bench was not available. Then what
Yes,
can
Your
be done?
Lordship. And I shall be grateful if tomorrow it could be fixed.
We'll see.
It could be heard.
We can't assure you. We'll see. What was if there was a last order fixing the matter? Then we may consider.
Yes, Lords. Because again, I will have to go back. So
see, we are telling you if there is an order, the last order was for fixing it on a particular date, then we will fix it. But that will be subject to seeing the order. Let us see the order. You will find out.
Yes.
You give the case number.
Yes, Lords. WPC.
Give on a piece of paper, sir. Everybody is mentioning, please. Yes. Give inclusion, it will come. All inclusions give.
Okay.
For inclusion, you give the.
Upon notice, my lord, I am sir.
For inclusion, you give the list. Slip.
May I have mention, my lord, for inclusion restoration application?
Give. Restoration list tomorrow or day after, any day.
My lord, may I have your
This
lordship?
is the application tomorrow or day after.
My lord, may I have your lordship's kind leave to mention an original side matter? Lordship, this matter your lordship was hearing had fixed it yesterday at 2 p.m. My lord, I was just humbly seeking any day convenient except for 4th and 6th of March.
My lord,
Any day convenient. Upon notice, I'm mentioning.
that matter.
Both are in the same matter.
Yes, my lord.
3 of us.
My lord, we have the dates, my lord. March 7th, my lord, if it's convenient, my lord, to my learned friends, my lord.
At 2 p.m.
Very
Can it be at 2 p.m.?
It will be. It will be at 2. 7th.
7th March.
Should may be permitted to mention.
Yes, please.
The matter, the hearing was over. This was the issue was that during the pendency of a criminal matter, whether a person is entitled to get the pension, gratuity, leave encashment, and other retirement dues on the ground of moral turpitude. The Lordship was pleased to hear this matter.
Oh, yes.
One day, it was over. It was supposed to come up for orders yesterday. It has not.
Which was not here. It will come. Don't.
And it is appearing as item number 141 of the daily list under the heading motion. So, Lordship,
Under motion.
under motion, adjourned motion. So, Lordship, it should go to a different heading and may be fixed on one particular.
Supposed to come for order.
May I hand over this list?
Yes, you may.
It will be taken up, Lordship.
On Tuesday.
Lordship, may I permitted to mention?
Item number 2.
Lord,
Just a minute, mentioning is not over.
mentioning.
Yes.
Lordship, may I permitted to mention one matter, item number 153 of today's cause list, Lordship. The petitioner is not getting his salary for last 2 years, Lordship.
You're not alone, sir. Yes. Next, anybody else? Yes, call the list.
Item number 2.
Your Lordship, I apologize. I pray for time, Your Lordship, not this week, Your Lordship. Mr. Mukherjee is appearing for is leading me in this matter. He has not come today, Your Lordship, due to Shivratri, Your Lordship. Not this week, Your Lordship.
The last order.
It was for orders, Your Lordship.
We have heard this. List on 10th. 10th, under the same heading.
Item number 3.
I am for that range.
Institute of Technology.
Yes, my lord, I am for the appellant, my lord. The list of this affected. থাকছে
Yes.
Yes, my lord, on the last occasion, while hearing the matter, my lord was pleased to come to know from me that initially petitioner was appointed in Ali College, then Ali College
Appointed in?
in a regional engineering college. I have given this, lordship kindly sees, I have prepared a note on it.
Yes,
It
yes.
will help, lordship given.
No, this you have given.
Another thing, my lord, on the score I have prepared it. It will help, my lord.
No, you are for the,
I am for
you are
the,
the applicant.
I am for the applicant, my lord.
What was your prayer before the tribunal?
It was not against the order of tribunal. It is a assigned matter before lordship. It is a mandamus appeal, my lord.
Mandamus appeal. So what was your prayer before the honorable single judge?
To quash and set aside the departmental proceeding, to quash the final order, including the order of the appellate. Just I pay your petitioner before your lordship.
So what was the charge memo? Let us see. Let us go direct to the relevant facts.
Yes, my lord.
What are the charges based on which the inquiry commenced?
Yes, lordship kindly charge is initially, my lord, page 66 of the volume 1 of the paper book.
Yes.
Page 66 of the volume 1 of the paper book. Its initiation, my lord, starts from page 66.
This is the opponent. Hmm? Why nobody is appearing for the other side?
Yes, on the last occasion.
Yes, they asked for a copy.
A copy has been given. Even he appeared in the next occasion when the matter was heard. He appeared through online process, my lord. That process is complete. And on the last occasion when my lord heard the matter, to some extent, my lord, he attended through online process, my lord. Already তো তোর নামে already আছে।
So what is your defense before the inquiry officer?
But the very first thing, my lord, my contention would be before your lordship. This director in charge who has issued the charge sheet, followed by suspension order, he is not being an appointing authority, cannot issue it. Is that a pertinent question?
So therefore, again, we are asking you, if he is not a competent authority, did you inform him that I will not respond to your charge memo because you lack the competence for issuing such a charge memo to me?
And in spite of the same, my lord, this person proceeded with the and passed the final order.
So where is, that is what we are trying to see. Where is your response? Where have you said that I will not submit my response because you are not competent to proceed against me?
The law says, my lord, I have to proceed because suspension order followed by charge sheet, immediately termination. I had no alternative. I had no alternative.
After charge memo, what did you do?
After charge memo, lordship kindly sees the list of dates. After charge memo, the final order passed. Then it was quashed.
What is the date of charge memo?
Charge memo next page, my lord. Page 67,
Yes, what is the date?
8/10/2004.
And how much time they have given you for filing the response?
And lordship kindly turn to page 69 for a while.
Yes.
List of witnesses. Have you got your lordship?
When we ask you something, why do you submit something else, sir? We are asking you what was the time fix for giving a response. You are asking us to see the list of witness. Why should we see that?
Lord, page 66,
7 days.
7 days.
So you were granted 7 days.
Yes.
In these 7 days, what did you do?
Subsequently, my lord,
We are not asking subsequently. We are asking you what did you do in these 7 days? You responded, you didn't respond, you responded by saying that no, I will not respond to the charge memo because you lack the competence. What did you do? Or you just sat there because he is not competent, I will not do anything.
my lord,
We
then,
want
my lord,
answer on facts. You will make your submission later. We are first trying to understand the facts.
this, my lord, the inquiry proceeded ex parte.
What did you do? We are asking you.
My lord, initially I could not give the charge.
You did not give any response.
Yes.
All right. So thereafter you did not give your any response. Then what happened? The inquiry officer proceeded.
Proceeded.
So what is the date of the order passed by the inquiry officer?
Initial order, lordship kindly. Then 3/11/24, one ex parte inquiry report was forwarded to the petitioner.
3/11/24.
24.
Where is that? At which page?
Then 11 page 76, page 76, volume 1.
'76 is not the inquiry report.
No, this is my objection.
Why are you doing like this? You want
Inquiry
us to
report was not
understand anything,
submitted.
or you want us to
Milord,
not
this was-
understand anything?
This was not
I asked you where is the inquiry report of
not, just
311?
not given to me.
So how did you respond?
Then, Milord, I objected to
Yes.
page 76, requesting to forward the your petition objected to such ex parte report, requesting respondent authorities to withdraw their actions. Then, Milord, lordship kindly turn to next page.
No, what have you written in page? This is the first communication from your side.
Yes, Milord. Then lordship kindly allow the to go to next page 2.
Just a minute.
Then the case was
Just a minute, sir. Oh, so rather than appearing before the officer, you challenge the same before the High Court.
No, before that,
In
lordship
WP
kindly turn to
20269 of 2004
lordship turn
itself,
to page 82 for a
where
while.
is the order passed by the High Court? In WP?
Page 82 for a while.
No, where is the order passed by the High Court? We will go in seriatim. We will not jump from here to there. We
No,
want to see.
I'm coming with you side
Come
by
to the
side.
High Court's order, sir, please.
Page 83.
Yes. After this order, did you appear before the inquiry officer?
Yes, my lord.
When did you appear?
I filed a reply, page 86. Please find to enter a bunch of 87 pages. It is with me. If your lordship desires, I can give it.
Page 86.
Page 86, I have submitted my reply. But the heavy punch, my lord, that's why it is not annexed, but it is with me.
So this was not before the tribunal. This reply
No.
was not before the tribunal.
No, it is not an issue before the tribunal, it is before the High Court, my lord. It is not.
Before the single judge, this
Yes,
inquiry report was not.
single judge, my lord. All these documents were placed.
It is there. Where it is at which page of the writ petition?
Lord, writ petition, I crave leave. I have annexed it, and this is the because it's a heavy point.
Therefore, we are asking you that document was not before the single judge.
The documents, my lord, I have handed over a copy.
Yes, we don't know. That's not part of the record.
But he has considered it in the
It
judgment.
has been considered.
Yes, lordship kindly just placing the facts, my lord. Then lordship kindly sees the judgment.
So thereafter, what happened? You submitted your response on 5/5/2005.
Yes, my lord.
Then what happened?
Then final order passed. Next page, page 87. আমি পরপরে বলছি তো 87 87
Yes. Then you went for appeal.
Just, my lord, then next page I preferred an appeal. And my lord wanted to know from me that whether you have taken this point that not being a appointing authority, whether the disciplinary proceeding can be initiated at the ends of the person who is not the appointing authority of the petitioner. This particular point I have taken, my lord.
First time in appeal. Inquiry report submitted. You approached the High Court. No such issue raised. Before the High
The
Court,
High
you
Court
said
said,
that
my lord, in
no,
accordance
you
with
asked the High Court to direct the disciplinary authority to proceed expeditiously. Your prayer is there in the writ petition.
my lord.
Come to your prayer. See
Yes,
your prayer in the writ
expeditiously, my lord.
Yes, come to page 84.
Page 84.
Yes, last paragraph. Advocate for the petitioner prays for order directing expeditious conclusion of the disciplinary proceeding.
Yes.
You have not raised any issue regarding the lack of competence of the inquiry officer. Nowhere.
Not facts remain is a point of law.
Yes.
It's a question to be argued. High Court said in accordance with law to be decided.
No. You said you are.
My lord, I cannot. If the law doesn't permit anything to do.
That comes later. First, you had not objected. That we are saying. The fact is that you did not object. First objection raised in appeal.
In lordship, kindly see page 88. This point I have taken.
In appeal.
Yes, my lord, that is his page 88.
Yes.
Point number 7, my lord, this particular
Yes,
point.
we have seen that. That's why we asked you. First objection taken in.
Then, my lord, after this appeal.
Now we'll have to come back to where is the act. Show us the act.
Yes.
Last day also we had asked you the same question. Show us the act.
I have given, my lord, a bunch also given a just, my lord, sees.
This is not the act.
No. I have given a bunch in the last occasion. A bunch compiles every act.
Bunch compilation.
Last day, my lord, a bunch has been given to my lord. And lordship kindly, in taking the bunch, lordship kindly sees the just I handed over this particular list.
This one.
This one is the bunch.
Where is the act? Let us see. Statute.
Lordship kindly sees it for a while.
We'll see that later. Show us the act.
Lord, this is NIT Act.
Yes.
Lord, in Lordship, for a while, for your my Lord's satisfaction, Lord, I will see in 1987, Lordship, just for a while, because if Lordship comes to this act, my Lord, query-based answer is given. 1987, the petitioner was initially appointed as a lecturer, RE College, Durgapur.
We have understood. You have argued this point. Don't
Yes.
need to repeat, sir.
Yes.
You are saying the NIT has come into existence after your appointment, and therefore you are raising issue of competence of the inquiry, the
Yes.
disciplinary authority. So let us see the act. What does it say?
Lord, charge sheet initiated, disciplinary bonded, under
Where is the act? Which is the relevant provision of the act?
relevant provisions act, my Lord, Constable. My Lord, disciplinary action and penalty is a rapid rule.
Sir, will you please show us the act whereby this institute was declared as an institute of national excellence? Since last day, we have been asking you to show that act.
My Lord,
Why are you shy from showing that act?
page, Lordship kindly turn to
Yes.
page. Page, the page 172
Of
the volume paper book. Page 172.
172.
No, my Lord, ওই sheetটা কোথায়? ওটা কোথায়? Just a minute.
The same question we were asking.
এখানে আসুন না। ওটাকে না কোনটা নোটিফিকেশন কোনটাতে আছে না ওটা না যেখানে নীল নোটিফিকেশন পেজ 172.
172 is not the act.
Yes, my Lord. Here, my Lords, the government had taken all service conditions of the employees of the regional engineering college upon their conversion. First subject, Lordship analysis. Upon their conversion as National Institute of Technology NITs with deemed university status.
We are again asking you since the last date, why are you not placing the act? If you are not interested, then we will not continue with this matter.
Which act, my Lord?
There is an act declaring the institute as an institute of national excellence.
By
The day it has become.
by notification, it has been declared.
Where is that?
The notification is not it has been mentioned.
So you don't want to show, in spite of the
No,
court's
notification is not
query?
with me. No, Lordship.
It is a public document, gazetted notification, sir. You as a lawyer saying it is not.
It is admitted position, my Lord. They have admitted it.
We want to see the provision, competence of the disciplinary authority is involved in your
That
submission.
I'll be showing.
We want to see the act. Why should we see any office memorandum?
No, act, I am referring, my Lord, CCS.
No, show us the act. CCS is not the act.
Act, my Lord, this is the act. This is the act.
When it became a NIT?
NIT, my Lord, became 14th May 2023.
14th May 23.
2003.
So 14th May 23, it became an NIT. How? Tell us.
By virtue of a notification.
Where is that notification?
Notification is not me, but it is mentioned in the memo.
Why not with you? Why are you not bringing it for the last 2 dates?
No, I could not. I am not in a position because it has referred
Very well.
to.
If a
And
lawyer
subsequently, my Lord,
if a lawyer cannot get a
my
gazetted
Lord, it has
notification,
been
then we
referred
don't
and
know what,
act has been prosecuted.
then
For
we
just,
don't know,
just
then we
last
don't
for,
know what to say,
no,
sir.
my Lord.
You cannot force us to hear
No,
something.
no, my Lord, Lordship, take me amiss. By
When we
virtue
have
of a
made-
notification,
when we have
subsequently,
asked you on the last day that we want to see the provision, you
Provision
are here
is
to
with me.
satisfy us.
My Lord,
We will
up-
not refer
my
to
Lord,
anything.
Lordship, sees the
You come
provision.
with the gazette
My Lord,
notification.
gazette notification
Let
is
the
not.
learned counsel come with the gazette notification dated 14/5.
The act,
Give us a copy of the act first. Where is it?
this act, my lord. Just lordship, would you,
Sir, you show us the act. We are here. We'll hear everything you have to say. Show us the act.
Lord, for the purpose of this particular NIT, Delhi NIT rule was adopted. Lord, this particular notification. এটা কি? NIT একটা পরে। And bunch kindly takes the bunch. Takes the bunch for a while. Everything is available. Everything is available. Everything is available. I submit 14/5/2000 notification is not me, but subsequently on the basis of this, subsequently act was implemented. This is the two act, NIT act. No, Milord, probably I cannot reach to your lordship. This is my friend. Where is my friend again, Milord? No, Milord, if your lordship takes the trouble to see this particular list of. Yes.
Because at the time I was appointed, as per NIT Act, it is not therefore, how the act came, what was it?
Yes. No. No, your lordship kindly calls for, this is not, I am not getting it 14. Or lordship kindly calls for this 14/5 notice.
You are not getting it. Very unique submission.
No, subsequently act is available, my lord. 14/5/2003 notification is not available, but facts in subsequently acts were incorporated in terms of which is to be proceeded.
It is the act. And then you say I don't have the notification.
Notification is no, act is with me.
Then why are you not showing it?
Yes, this is the NIT Act 2000. Yes, these are the. No, lordship probably I do not reach to. But this act came into force subsequently. Yes, before that, my lord, this NIT rule 2000 was adopted. It was adopted.
As per this, what is the regarding those who were in service at the time of if the act has provision, how do you keep
I tell you, my lord, this particular act came into force in 2007. Before this act came into force in 2007, my lord, the NIT Act of Delhi was adopted and IIT rules of Delhi was adopted, and it was supposed to be dealt by the IIT Act of Delhi. Well, this particular bench I have given to your lordship in the bunch. That's why, my lord, I wanted to show your lordship. This is for 2000. Before that, my lord, before that lordship kindly see. Yes. The chapter 5 of disciplinary action and penalties and appeal rules. This is the applicable rule. Yes, I have marked the page, my lord. A4, my lord, chapter 5. After the CCS rules, it has been given.
175 of volume 1.
One 74, volume 1. One 74. 174 it is. Page one, two copies I have given. Page 174 of the volume, paper book, Lordship analysis, paper book. Volume 1, page 174. Competence according to this. Yes, my lord. Board of Governors, page 175. Page 175. Disciplinary, BCGB disciplinary proceeding deals in 5.1, page 174. Yes. The following are the disciplinary authorities for the various categories of staff. So this rules of this IIT New Delhi provisions were adopted by the. Yes, page 177. NIT. Yes, 1.750. Yes. The chapter 5 of the administrative manual of IIT Delhi Interior deals with the disciplinary action, penalty and appeal as prevalent, be approved mutatis and mutandi as conduct and disciplinary rules for the employees of NIT Durgapur. So this is adopted on 30th January 2004. Yes. Why you are referring to 5.1? Yes, I am referring 5.1 disciplinary authorities. Yes. The following are the disciplinary authorities for various categories of staff. Director in case of staff appointed by him also for office superintendent such and such. Board of Governors
in case of any member of the staff. So, my lord, here I join, my lord. I am a teaching staff. Therefore, my appointing authority is
And
board
what
of.
is the date of your this charge memo?
Yes, my lord.
8/10/2004.
Yes. Before that, this act came into force.
No, how it is before?
Yes.
Oh, yes. No, it is after this.
Hmm.
Charge memo is after this.
After the incorporation of the.
After the incorporation of this act, charge
Yes.
memo. Therefore, my lord, when the charge memo issued, the director had no authority.
But you just said before this. It is not before, it is after. this.
After. Then, my lord, 5.2 deals with appellate authority. Page 175.
Page.
175, my lord. I have referred disciplinary proceeding, then appellate authorities. 5.2.
EOG.
Yes. Now, in case of order imposing penalty by the board, my lord, this particular
In case of penalty imposed by.
imposing penalty by the board, visitor to be, I am to approach before the visitor. If the board is, then on that score, lordship kindly see the order of justice Dipankar Datta, my lord.
No, so it has been considered by the visitor.
Yes, ultimately,
Yes.
it is not considered by the visitor.
No.
No. What happened, my lord?
Yes.
I moved Justice Dipankar Datta's order. If your lordship kindly turn to page 159. There has been, my lord, starts with 159. It has been, my lord, somehow reversed.
Maybe you come to page 185, sir.
185.
Yes. Your appeal was placed before the visitor. There was a direction that the visitor should pass an order.
Yeah, and Honorable High Court also directed.
Yes, so it was placed before the
Then, my
visitor.
lord, near I came, visitor did not pass any order.
Yes.
It is simply the proposal of the MHRD has been accepted.
So therefore, don't say visitor did not. Visitor may have passed an order not to your liking, but
No,
visitor
no.
has passed the order.
I refer.
Yes.
It is simply a proposal of the MHRD.
Accepted by the visitor.
No consideration. Even
Therefore, it is by the visitor, but not no proper consideration.
my
Where
submission.
is the order of the visitor?
Yes, my lord. Proposal of the
Where is the visitor's order?
page 303, my lord, volume 2. দেখো তো। There. Lordship got it, page 303.
Yes, we have got it.
Subject, consideration of the appeal of Dr. Sachin's ex-faculty member of the Association Kapoor filed by him against the order in respect of disciplinary proceedings, charge sheet dated Atho, in accordance with NIT Act 2007, my lord. Lordship kindly sees that that act came subsequently. How they can apply this act? I don't.
That's why we are required to see the act.
NIT Act is with me.
That after coming into force of the act, what is the provision? Therefore, we have been asking you, that
Yes.
where is the act?
Then let me complete it. I am submitting. And NIT Act just given.
Yes, now you have given.
The
After
first
2 days.
acute forwarding necessary proposal. The president in his capacity as visitor of the Russian Institute of Technology, Durgapur, has been pleased to approve the proposal contained in para 3 summary at P. This is the simple thing.
Yes, we have seen that.
And Lordship kindly see page 298. This is the proposal which has been simply accepted by the visitor. In fact, there is no consideration.
Where is the proposal? At which page?
Proposal at page 298 of the same paper book, my lord. Statutory provision, Lordship kindly mark it. NIT Technology Act 2007.
Yes.
My lord, seen there is no consideration of anything. Simply recommendation. And visitor has accepted it. And on application of NIT Act 2007.
So therefore, there is no issue of the competence of the inquiry officer or disciplinary authority. It is a question of the order passed by the visitor being without consideration.
Visitor without consideration, even the MHRD is without consideration, nothing of any sort. Then I would like to go to my lord to substantiate and act applied in 2007.
Even if the 2007 or provision section 24 বলছে the board সেটা বলে please board Section NIT Act is for arguments.
My lord, even the argument says is taken as 2007, my lord, section 24 clearly see.
Of the NIT Act says that the board has to be done, even if an arguments are given, though not
No, no.
applicable in this case. It's a question of policy.
এবারে দেখাচ্ছি সেটা
এটা তো NIT Act
কোথায় লেখা আছে কথাটা ভুলভাল পড়িস না ভুলভাল পড়িস না পড়, যে ও বলছে ও কথা ছেড়ে দে তা দেখাস না ও এমনিতেই খেচার খেচার করছে বেশি
তাড়াতাড়ি মাইকটা তো
এত এই টিপিটা দিয়ে এই টিপিটা দিয়ে এই রুলসটা 2007 সালে
Yeah.
অ্যাপ্লিকেবল এটা কি জানি কি দেখ আরে বাবা ওটা তো লাগবে এটা
Yes.
Lord,
Yes.
now lordship continued for a while because I am fortified by my lord's judgment. My lord's judgment. My lord will be filed from the charge sheet. Certain witnesses was referred. From the initiation, I said, my lord, the appointing authority can only initiate a disciplinary proceeding. Rules covers it.
Yes.
One problem I am facing, my lord, that's why, my lord, I'm a bit slow in my blood. Yesterday I got a very choked voice. That's, my lord, I cannot continue vividly, my lord. Lordship, take me and don't take me. I mean,
So if you want, we can do it on another day.
just, my lord, that's, my lord, I'm just summing the point so that I will argue on this point, nothing more. That number,
No, if it either today or some other day, no piecemeal. If you cannot conclude today, you argue
some
on
problem
one day.
is with me, my lord.
Then all right. When do you want? Tell us.
Day after tomorrow.
All right. As prayed by Leonard Counsel for the
My lord,
petition.
because of my problem, my lord.
We are You could have said at the beginning, necessarily about an hour's time we have wasted. Yes.
Lord, I'm not,
Anyway,
I thought I could continue, my lord.
yes. Keep.
Item number 4.
My lord, according to your lordship direction, I file section 5 of the Limitation Act 1963 and copy served to Union of India
And you have got the certified copy now?
Yes, my lord. So, my lord, 2 application already filed for obtaining the certified copy of the judgment. First, dated 8 August 2024 and 13 July 2024. Already I received 2 certified copy and filed an application of MAT, tender of mandamus appeal, but 1 copy, my lord, already I have filed on 12 August. Till date, my lord, 7 months passed away. I did not receive the certified copy of the judgment. Page number 8, my lord, kindly see it.
Page number 8
8.
of today's application.
Yes, my lord. So, my lord, I put up an application for certified copy of the judgment. Already I made the section officer at member section, but they denied that the record is not available. For this regard, my lord, I reached at my neighboring place at Bihar, Saran district, and obtained the Xerox certified copy and filed an application of MAT on 12 September 2024, my lord. So, my lord, may kindly allow my application.
You are challenging which order?
Page number 8, my lord, certified copy of the application. And till the date, my lord, I did not receive the certified copy of the judgment which was passed by Tapovarta Honorable Justice
Lordship, the
Tapovarta Chakravarti.
stamp
and
report is report regarding the delay, Lordship. Lordship, is it 4 days or more? That is what I was being confused.
Stamp report says
certified
32
copy
days.
did not receive it,
It
my
says
lord.
4
For
days.
this regard,
In the
just
application,
copy
he stated
certified
4
copy
days.
already I
4
received
days.
and file an application of MAT.
That is sent. That has to be given as application.
May I kindly see page number 8.
We had asked someone to help him on the last day. $32. Yes, we had from the
The prayer and the pleadings are 4 days. But
criminal revision application.
$34. Both prayer and the pleadings.
The other day, we had asked a learned advocate that he will help you. Did you meet him?
Yes, my lord.
We don't think so. It can't be you are seeking condonation of 4 days delay, whereas the stamp reporter has delayed 32 days, reported 32 days. You are seeking condonation of 4 day delay in filing criminal revision application. This is a criminal revision application. We had asked the learned advocate to help you. He had agreed. He was gracious enough. You have not taken his help. Because after taking help, this can't be. How can you pray for 4 days delay if there is 32 days delay? You are not filing a criminal revision application. You are seeking delay in filing criminal revision application.
My lord, already I am filing, but the certified copy.
Forget about certified copy.
4 days delay, my lord, I reached at my neighboring place and.
How many times again you are saying the same thing? You have come with only these 2 lines. You will keep saying whenever we ask you anything. We are asking you why your petition is not in order. You have not taken his help. He was gracious enough. He told us that yes, he will help you. You have not taken his help. You have not taken any counsel's help. Forget about it. That person. You don't want to help yourself, then what can we do? If you don't want to help yourself, then we only tried. If you don't, then we can't help you.
So, my lord, so you consider the matter.
What consider? Your application is not in order. On the last occasion when the matter was taken up.
Lordship, could it be after the 15th, Lordship? I will not be there.
After 2 weeks,
It's my learned junior.
let's
If I have
see
not
whether he
been, let's
brings
see
it in
what
order.
happens.
If it is,
No. I wouldn't have stood in the way either. I wouldn't have stood in.
নোট করা আছে তারা তোমরা বিলটা আমাকে দাও number 5, 6 and 7 I am for the petitioner. My lord, kindly first of all, my lord, take up my lord item number 6, the main writ petition.
The 6 I am not appealing.
ঠিক আছে. May I submit from item number 6 similar issue, common order,
I do not know who is.
because item number 6 my worker.
Mr. Mukherjee, what is your difficulty?
5 and 7.
You are not appearing in 6. If they all are the same, then
Same.
Then why do you want to go on?
My workout is item number 6, that WPST number 28. May I proceed? Similar rule annex.
Everything is similar. We had started with 5, I think.
Yes.
So you proceed with 5.
Yes. 5টা কোনটা আছে? ঠিক আছে রাখো.
In the meantime, you ask whoever is appearing in 6 that he or she should ask him to come, please. All right, let's see. We'll see.
Okay. May I rephrase my
Please,
argument?
yes.
This is the recruitment for the post of West Bengal police constable,
Constable.
male and female,
Yes.
both posts. Advertisement was published in the year of 2020,
Yes.
which is at page 61.
Yes.
In the advertisement, there is a notified vacant post of 7,440 for male and 1,192. Total notified vacancy
8624.
8632. But they publish the provisional list 8624. Yes.
1500 did not join.
Did not join. But now kindly see the advertisement, the provision of the and the condition laid down in the advertisement,
Yes.
which is set starts from page 61 and relevant is page 63.
63. Yes, we have it.
Yes, 63. Point number 4 at the top. The method of recruitment. First, the candidate who have participated in the selection process, they have to participate in the preliminary written examination, which a Shanal is leading.
Please. Come.
Advertisement item number proceed.
So we have been informed till now that there is a provisional select list of 19423, wherein a list of 8624 candidates has been published. After publication of this select list, the vacancy on 1500 posts remain because of non-joining for some reason or the other. So therefore, they are saying that a direction be issued for consideration of the petitioners against the 1500 vacancies remaining unfilled.
Malad, only one thing, Malad.
Yes.
There was no non-joining point. They were not at all appointed. I just tell you, Lordship, the scheme of the
So we said for any reason whatsoever.
that because non-joining, if your Lordship, my learned junior says it, but that's wrong, and that might go against me.
No,
This is
non-joining.
not joining.
For any reason, the post has remained
Appointment was
vacant.
not at all issued.
All right.
Appointment not at all issued.
And they are not before us that why our appointment was not
because
issued.
I tell you, Lordships, there was a provisional list of recommendation according to the advertisement.
Provisional select list. Yes.
List of recommendation.
All right.
Now, from this list, they have to undergo medical test and Malad character antecedent test. They have to
Verification of credentials and all that. Yes.
After compliance of this, Malad, the appointment letter is to be issued. Out of 8624 candidates, 1,500 odd didn't do that at all, didn't appear at all. Therefore, there was no question of issuance appointment.
Therefore, that amounts to non-joining. They never turned up. They were not interested.
As I find from the several judgments and orders.
It is not after making them eligible or selecting them that they did not join. They chose to abort their candidature.
They didn't participate in the process.
Correct. They aborted.
They were not, therefore, they were not issued appointment.
Very well. Yes.
Now, the point is, your Lordship, now.
So, from the recommendation, it did not fructify into issuance of an appointment.
Now, this is.
They have not completed the stages.
Therefore, the stages were not completed.
Correct.
Now, your Lordships, this is your Lordships, there was no panel. Now, the point comes up, who are on the merit next, why they should not be called up for the test.
First of all, the question which arises, which is maybe a precursor to this submission is, do you know that you are the next person? Or do you know that within these 1500 you will come?
That I can show.
From where you show? Because from what we understand on the last day, beyond 8624, there was no publication. So if there is no one published beyond 8624, how do you know that you will come within the remaining 50?
This was placed before the learned tribunal also.
Ankita Goswami, petition number 1, item number 5.
Now, your Lordship, this was published by the Police Recruitment Board also. Kindly see the heading of it. Not recommended for recruitment to the post of Constable and Lady Constable in West Bengal Police 2020 recruitment process. Kindly go down bottom. Last but one, Ankita Goswami. He is the first petition. So, if the 1,500 vacancies are taken into consideration, obviously she will come up.
How do you say that?
Because your lordship kindly see the serial number.
Yes.
This is on the basis of the merit.
Oh, no. This is a list of not recommended candidates.
Exactly, your lordship.
Yes.
Exactly. This is not
Not recommended means who did not qualify.
No. That's the point, your lordship.
We don't
That's
know.
not the point.
If this was part of the pleading before the tribunal, otherwise we'll not look into it, sir.
That we can file and buy one affidavit, your
Not
lordship.
now, sir. Whatever was there before the tribunal, we are not going to enlarge that. We are not going to enlarge that.
Now, your lordship, this was the publication of them. Now, your lordship, in the last document, last page of this bunch of document, if your lordship kindly take it up.
We are not going to consider anything which was not before the tribunal. This is not the place, the point of first instance.
Well, I understand that.
Therefore, we are not going to consider.
But if your lordship, for ends of justice, something
No,
record-
sir. If that is a case you were required to make out before the tribunal. We are here to see the correctness of the decision passed by the tribunal within the scope of L. Chandra Kumar. We are not going to take up the issue as a first court.
All right, I will try to demonstrate that, but your lordship kindly have a look at this bunch of
If
paper.
this was not there, we would rather not. Let us confine to the records as they are and proceed accordingly. Yes.
All that I'm trying to show you, lordship, the cut-off marks was published. They are almost equal to the cut-off marks.
Maybe, we don't know.
Now, your lordship kindly.
See, maybe when you say maybe equal, in a difference of 1 mark, there may be 3,000 or 5,000 candidates. It is very common knowledge in such a competitive examination.
No,
In a difference of 0.5, there
Yes,
may be a
yes.
difference of 5-10,000.
1, 2 also.
Therefore, it is hardly anything. You cannot draw a presumption that because the difference between the last selected and you is 1 mark, therefore you will come within 1,500. Therefore, we ask you, that is a case you can make out only if there is a panel, a merit list which contains candidates even beyond the cutoff mark. Then you may be in a, and there are examples of such procedures. Then you may be able to say that yes, we are at the 5th position after the last candidate. We are there to be. But that's not the situation.
But I tell you, there is no waiting list.
There is no waiting.
No rules also. Malad, may I proceed with the advertisement first?
Yes.
Malad, it starts at page 97.
Yes.
I will take your losses only to the relevant provisions of that.
No, page 63, not 97.
Page 97, your lordships.
Item number 6.
It is 6.
হ্যাঁ 6 এর brief এটা তোমার
Oh, Mama. তাহলে তো অসুবিধা ওটাই
না এটাতে তাহলে করো এটাতে করো আমি পাশ দিয়ে বলে দিচ্ছি
all right.
You are referring to clause 4 of the recruitment. Clause 4.
Clause 4.
Yes.
But, the post of constable and lady constable in West Bengal police shall be filled up on the basis of qualifying the preliminary written test, which will act as screening examination, followed by the physical measurement test, such and such PMT, physical efficiency test, final written examination, and interview to be conducted by the West Bengal Police Recruitment. Malas, there was a preliminary written test for 100 marks. All of the applicants or petitioner before lawsuit, they crossed this hurdle. Then your losses kindly see B, physical measurement test and physical efficiency test. All of the petitioners before lawsuit also crossed these hurdles.
Yes.
Then your losses final written examination. All the candidates who qualify in the physical measurement test and physical efficiency test will be called to appear in the final written examination to be conducted by the West Bengal Police Recruitment Board. Now the final, then your losses says how much marks will be given. Then your losses note there will be negative marking. We are also not concerned with this, your losses. Your losses kindly come to the next page. Page 64. Interview. A limited number of candidates. Well, this is very important. A limited number of candidates will be called for interview in accordance with merit. In the interview, general awareness and suitability of the candidate for public service will be tested. Well, we came within this zone of consideration also. We were interviewed.
And is there any stipulation as to how many times candidates will be called for?
No, that's I do not find.
That's not.
No, nothing. No provision. We were interviewed, therefore we were, my lord, in accordance with merit we came.
দাদা এটা
Then
yes.
this
provisional list.
The very next paragraph, on the basis of the marks obtained in the final written examination and the interview, a merit list of the provisionally selected candidates will be prepared by the West Bengal Police Recruitment Board. Then, Malad, candidates will be able to speak Bengali. That's different. Malad, therefore, Malad, this is provisionally merit selected candidates, merit list. These were prepared. Malad, admittedly, we were not within this. Admittedly, Malad, there is no Malad factual.
This is the 8624.
8624. Out of total vacancy, 8623. All right, 8624. Now, your lordship. Kindly see clause 7. After this, my lord, all provisionally selected candidates will be required to fill up a verification role, which will be thoroughly inquired into by the authority concerned. This is first. Then second, medical examination, clause 8. All provisionally selected candidates will be sent for medical examination at the state government designated hospitals. The selected candidates should be in good mental and physical health. They should be free from any deformity likely to interfere with efficient performance of their work. The candidates will undergo all necessary medical tests as prescribed by the Department of Health, Family Welfare from time to time. The certificate of medical fitness will be issued by an authorized medical officer. Therefore, your lordships, after crossing these two hurdles, then clause 9, Assistant General Inspector of Police will be the appointing authority. Therefore, the appointment comes, my lord, after completion of the verification of attendance and medical examination. My lord, they called all the candidates, but out of this 1500, odd candidates didn't either filled up their forms or my lord, they didn't appear, chose not to appear. Now, here, my lord, the point comes up. What would be the next vacancy? Whether the candidates who are on the merit in the list after the 8624, they have any right to be considered by this verification role or not? This is the point, your lordships.
The final selection list published by the recruitment. Final selection list কোথায়? Final selection list কোনো provision নেই, কিন্তু না বেরোলে তুমি তারপরের ক্যান্ডিডেট গুলোর লিস্টে আসবে না।
Therefore, your lordship, kindly consider there was no, after all, Malad, suppose your lordships, if a candidate didn't qualify in the verification, character antecedents. So he should be ousted from the provisionally selected merit list. This is not the final merit list, your lordships. It presupposes that there must be a final merit list after compliance with the provisions of clause 7 and 8. It presupposes, my lord. Though I do not find any express provision.
Normally, this verification of character and all this is after the selection is finalized.
But your lordship, language says provisional here.
That is the expression they use
Expression they
because they find that it is subject to
I will not
medical as well as.
But
And
here
this is a recommending bodies exercise at this stage.
My lord, therefore, my lord, if I argue on this, my lord.
And plus, this is a term in the advertisement which we all know about from the day it is published.
Exactly.
As to how it is to proceed.
Therefore, provision. This is provisional, not final. Now, my lord, I could argue before your lordships that since this is a provisional, after somebody fails to comply with 7 and 8, the next will be called on.
By inference.
By inference. My lord, there is some logic behind it.
By logic and inference, therefore we are saying not express, but by logic and inference.
I could have understood that there is an express provision.
Yes.
That my lord is otherwise.
No, but in the absence of such an express provision, the law is very clear. Is the court to read in such a inference in a recruitment process, public recruitment process? Is it permissible? Therefore, this is the next issue which will arise. Therefore, we are asking.
Now, here your lordships, my lord. Just now, your lordships. Now, therefore, the point comes up. Selection process has not yet come to an end. My lord, selection process consists, my lord, starts commence from the date of advertisement. It ends on the date of appointment. Well, I'm frank before your lordship making submissions. If there had there been appointment letters in respect of this 1,500, I didn't have any case. Because Appointment letter you issued, nobody joined. I do not have any right unless the rule makes a specific provision. Here, your lordship, this is not final.
And this is for which year?
2020.
2020.
Yes.
May I disturb your lordship? Just 1 second. Just 1 second. There is a order of the Supreme Court all over India that police, the government of West Bengal and by the Honorable Chief Justice and but that every year, my friend knows, every year there should be about 8,000 vacancies to fill up. But this order was passed in under last.
First, give him a copy, then you make it.
But probably state always suffer lack of documents or the copies.
Judgment.
Obviously, Mr. Mukherjee will not have the second copy, the spare copy. Anyhow, we follow.
No, we would rather you see it first. Give him.
Yes.
Only after you see, then we'll see it.
But that's just give me. But there is a direction.
No, is there any specific direction regarding this process?
No,
No.
this process also, this continue. According to the direction of the Supreme Court, we issued the selection process 2020. But because we have proceed, there were 2022 when selection process in terms of the order of the Supreme Court, about 8,000 something. Then in the meantime retired. Then we shall have to conduct this selection process during the COVID period also. Then after 2022, this process continued. Then went up to reached up to this court. Then selection process was OBC and other categories were changed. Mr. Sanal also appeared. Then we are selecting the person 2023 selection process started. Then whatever the vacancy filled up, we have forwarded the numbers to the 2023 way. Then again 2025 selection process we have started, but because of the OBCs we have stopped there. But
so what you are saying that as a result of multiple litigation, the vacancies have been carried forward in the next process.
Yes.
In 23, then 25. Let us take it has not been carried forward. Even then, even if it has not been carried forward, they may argue that we are only concerned with the state of affairs as it existed when we came. But whether in the absence of, therefore, we have made a query and both of you will have to address us. That in the absence of such a provision, can we make the recruitment process or that reservoir to be a perennial source, or that amount of vacancies remains even in spite of, or it can be said that the process is incomplete, because then if what you say, even if one candidate does not join, the process remains incomplete.
I tell you, Lordship, kindly excuse me. This is not a case of non-joining.
No.
Non-joining only after appointment. This is
You
the
have
fine point I
already
tried
said
to.
that. We have said that for any reason whatsoever. So therefore, we are saying for any reason whatsoever, once a provisional select list is published in terms of the advertisement, and say 2 candidates did not join, then also you could have raised this issue. Or 2 candidates were not found eligible in the process. They were not finally issued the appointment letter. Then also you could have come.
I could have. In the second situation, I could have.
Yes.
Because it doesn't terminate. The process doesn't terminate.
So therefore, that is what is the, when you say appointment process begins with the date of issuance of advertisement and concludes with the issuance of the final
letter of
appointment. Does that mean that conclusion is always when all the appointments are given? Or by issuance of appointment letter means that out, even if 50% have been found eligible and it is concluded, it concludes. The point is whether the remaining vacancies remain alive after issuance of appointment letters to those who have finally emerged successful in the process.
If your lordship put me question in this way, that after issuance of appointment letter, I do not have any case. I'm frankly saying.
These are the facts which are born from your
this is not the appointment letter issued.
No,
everywhere your lordship appointment letters are
letter
issued after.
Not appointment letter issued or finally the selection, because the here clause 6 which you read, that is the final conclusion of merit.
No, my lord.
No.
Provisional, because merit depends upon antecedent. Suppose your lordships, if a murderer has been selected in provisional.
That is not a part of the merit. That will become a disqualification.
My lord,
That candidate will suffer a disqualification. That will not erode or undermine his merit or performance in the recruitment process. That will stare in his face as a disqualification. In spite of emerging successful, he will not be able to enjoy the fruits of his performance. That is not the merit finalizes at clause 6.
But your lordships, if we read the terms of the advertisement,
So we have understood what your submission is, that once it says provisional, it means provisional.
exactly, my lord, always
Yes.
provisional, and then your lordships see, after verification of antecedents and medical exemption, only can be appointment letter issued.
Yes, yes.
Now here your lordships, this is the factual my lord, background. Now your lordships will find what the process here, your lordships. 154 টা কত হবে?
154.
No, your losses. I have worked out in another copy. That's why papers do not tally. Anyway, I give you loss. Communication dated 26th April 2023.
Take your time.
Pay
Tally
your
it
lordships.
Yes.
142.
from this brief that we are taking.
Yes.
Yes. Sir.
142.
I try to take your losses. What's the intention of the government? How they have read these provisions? How they have read? That's very important.
This
they have
is
read
one-
according to me what I submit before you.
This is the notification of provisionally selected.
Exactly. 26th April 2023. Subject. List of provisionally recommended candidates for appointment to the post of constable, lady constables in West Bengal Police. Well, this was addressed to the Director General of Inspector of Police by the Recruitment Board. The West Bengal Police Recruitment Board was entrusted with the responsibility to conduct the recruitment process for filling up of 8623 post of constables, lady constables in West Bengal Police 2020, male and female, by the memo dated such and such to the government of West Bengal Home Affairs and such, dated such and such. The newspaper advertisement inviting application from the eligible candidates was published on 19 January 2021. A total of 9,45,370 filled in applications. Forms were received during the 1 month's application window of such and such date. 183 offline candidates, including 81 candidates, were given the opportunity to submit application for the post after condoning their upper age limit in pursuance to the order passed by the Honorable High Court, Calcutta, in the matter of such and such. Out of the application forms which were received, 9,15,594 candidates were called for preliminary test held on 26 September 2021. On the basis of result of preliminary written test, candidates 1,07,887 candidates were called for physical measurement and physical efficiency tests, which were conducted with effect from March to April 2022. After completion of PMT and PET, the final examination was held on 22nd May 2022 in respect of 41,254 candidates. On the basis of the performance in the final written examination, 17,539 candidates were shortlisted for interview, which commenced from August 2022 and concluded on September 2022. On the basis of the total marks obtained in the final written examination and interview, the West Bengal Police Recruitment Board has provisionally recommended 8624 candidates as per the breakup. Therefore, your lordships will find provisionally recommended right hand side, your lordships will find male 7432 and female 1190. This takes us to 8624. Then your losses will find next paragraph, your losses, there was certain dispute in respect of certain candidates that was sorted out. We are not on this. Then the category wise authenticated merit list of provisionally recommended candidates enclosed in the booklet form. Another list of further details of the provisional merit candidate which is enclosed in soft copy is we are not aware of this. What does it mean? Another list containing further details of provisionally recommended candidates. Anyhow, your losses. Next page, your losses.
So did any one of you proceed beyond the final written examination?
All of us.
All of us.
All of
Beyond-
interviewed.
Beyond final.
All of us interviewed also. But we didn't, my lord, within 8624. Provisionally recommended.
150. Procedure of verification.
Now your losses will find, my lord, page 150.
ভেরিফিকেশনের পার্টটাকে কিভাবে কেন 6 এ আছে এটা একটু পুরো তারপরে রেগুলেশনটা দেখাচ্ছি
Now here your losses were, this is of 2nd June 2023. My lord, kindly see the, my lord, subject, police verification and medical examination report of provisionally selected candidates. Enclosed, kindly find here with a list of candidates provisionally selected for the post of Constable in West Bengal Police 2020 receive from such and such. Now your losses, I take it your losses to the relevant clause, next page 151, clause 6. This is, my lord, according to me, my lord, title, it, my lord, gives us some idea how it is to be, my lord, interpreted the clauses of the advertisement. If any candidate does not respond or collect the blank verification form and deposit the same within 7 days, a report may please be sent to this office for taking necessary action against him or her from this end. Lord, according to us, my lord, this means that if they doesn't report, my lord, for taking up the forms, therefore their names should be excluded from the provisionally recommended list and from the next meritorious candidates will be called on. Then your losses will find this provisions, my lord, who are they, my lord, all that. My lord, if you page your losses, regulation. Thereafter, your losses kindly take up page 153. This is the, my lord, rules. My lord, your losses will find these rules may be called the West Bengal Police Recruitment of Constables and Lady Constable Rules 2017. My lord, here in these rules, my lord, rules 11 to 14 are relevant. Because others, my lord, who, my lord, they exactly, my lord, they have quoted in the advertisement form, advertisement notification, my lord, rule 11. Kindly see your losses. Rule 11. Preparation of merit list. The final merit list of provisionally selected candidates shall be prepared on the basis of the total marks obtained by the candidates in the merit written test and interview. The final merit list of provisionally selected candidates. Malad, let us proceed further. Then, Malad, I will make my submissions on this. Then, Malad, 12, verification of testimonials. All the candidates provisionally shortlisted or for the interview will be asked to appear for all relevant testimonials. The procedure, date, venue for verification of testimonials. That's, Malad, relating to testimonials. Then 13, verification of character antecedents. All provisionally selected candidates shall be required to fill up a verification role, which shall be thoroughly inquired into by the concerned authority. Then clause 14, medical examination. All provisionally selected candidates will be sent for medical examination at the state government designated hospitals. Then your lordship 15, appointing authority. This is your lordships. Whatever we get your lordships in the advertisement, that has been quoted your lordships exactly. Except your lordships, kindly if I read, my lord, rule 11 and clause 6 of the advertisement, there will be a little variation.
Next হচ্ছে 15 টা appointing authority তার মানে appointment যেটা implied থাকলো stage of giving it 15 interview candidate.
Yes.
Now here your lordships will find rule 11 says the final merit list of provisionally selected candidates shall be basis on the total marks obtained in the written exam. And rules, clause 6 of the advertisement says, on the basis of the marks obtained in the final written examination and interview, a merit list of the provisionally selected candidates.
So they are in harmony.
Final words are not there. Rule says final.
Yes.
What I am trying to submit before lawsuits, this final merit list will be prepared amongst the provisionally selected candidates after the this verification of antecedents and medical examination. Because it was kept provisional. If they do not get the number of candidates equal to the vacancy, then the next candidates will be called for. That's why they didn't prepare the final merit list.
So what is there in 6 which is at variance?
Your losses will find on the basis of the marks obtained in the final written examination and the interview, a merit list of this provisional.
Yes.
Here says the rule, the final merit list.
Also, final is not mentioned.
And not mentioned. So it was kept open because it is in consonance with, must be in consonance with the rules. Therefore, final merit list they didn't prepare. Because of this, somebody found disqualified, as you also points out, or somebody didn't chose not to appear. So he was not ultimately selected. Disqualification, judgment of disqualification is also a part of selection.
So missing the word final is missing, therefore it has to be read in a different context.
Not different context. All that I'm saying that this is not final. Provisional select list is provisional.
Oh, the expression as it appears from the rule, because the rule have to prevail.
Rule have to prevail. Rule has to.
The rule says
final merit.
Assessment is final, selection is provisional.
Select, this is as I try to make out before lawsuits, why this was provisional. If somebody found disqualified for any reason for both the tests, there's somebody who is in the queue.
But then even after issuance of appointment letter, there are instances galore where even after the appointment letter is issued, in the appointment it is said you are provisionally appointed subject to verification of your
appointment.
So therefore, merely because the selection or appointment is provisional, does that mean that the appointment process is not over?
Because according to my as I have read,
we are trying to understand
according to the service jurisprudence, process terminates only upon appointment.
Correct, not appointment of each and every candidate.
That's
a process. No, so we'll have to see if you can show us any precedent like that, then there is no difficulty. That unless each and every candidate for which the advertisement is issued is not filled up, a process will not be considered to have been completed.
That's the line of judgment of this.
Let us see. So we'll see that.
Then your losses. According to me, they have also read read like me. I will show to your losses. They might argue before your losses in a different way, but their stand in the documents is that. Now, 172 এখানে কত? কি আছে কত? RTI application কত রকম? Your losses.
Again, they RTI application, Bengali ভাষায়।
এটা বেঙ্গলি কি করে দেখাবো জোসেফকে?
তুমি শুধু কোশ্চেনটা বলে
দাও। Your losses. I'm sorry, Malad. Page 160. This is in Bengali vernacular, but I try to Malad.
Then you are not quite kind to the court, sir. You should be kind to the
because no. Your losses are never to our state. So I presume that your losses also knows to an extent. Listen, Bengal, Bihar, Odisha, once your losses one.
Still that law is still there.
There are civil law, there are Bengal, Bihar, Odisha there. First appeal, miscellaneous appeal.
তুমি কোশ্চেনটা চলে যাও, অ্যানসারটাতে চলে আসো। কোনটা বল? ওই তো কিছু তো বলতে না, তুমি অ্যানসারটাতে চলে আসো, ওখানে তো সেন্টেন্স।
This is something obtained under RTI.
Yes.
160.
I give you what is their answer.
164.
What is the query and what is the answer?
I give you loss.
এইখানেই আছে, তুমি দেখো না, এখানে ইংরেজিতে লেখা আছে।
Your losses will find stateway page 164. Question answer both are there probably, or the answer makes it clear.
Sentence
in sentence is clear.
Yes.
Now kindly see your lordships. Point number 3.
Yes.
This is the answer out of the RTI. Your lordships will you can presume your lordship very well that what was the question. 8624 candidates have been provisionally selected for the post of candidates in West Bengal Police on the basis of recruitment of Constable 2020. Out of that, PVR of 7077 candidates have been completed. Therefore, your lordship, 86 out of 8624, only 7077 candidates cleared their verification role. Then point number 6. Our 8624 candidates have been provisionally selected for the post of constables in West Bengal Police on the basis of the recruitment of constables 2020. Out of that, MER, medical verification, 707 double candidates have been completed. So out of this, therefore, out of 8624, 707 candidates have been completed. Therefore, your lordship, so far this number of candidates selection process is complete, not the rest of the vacancies. Now,
previous page.
just before lordship, consider page 163. Before just the previous page. This is of 16th August 2023. With reference to RTI application received, the total 6997 candidates are joined.
Then there is a difference.
Even after
No, just now you said 7077 has been completed.
that's they completed.
All right.
But out of that, even somebody didn't join.
All right.
I cannot claim in between these.
Where is that?
Page 163.
So this 163 is a later RTI information.
RTI information.
5 days later.
Same 6997 candidates are joined at different training posts. All that I'm trying to make out your lordships.
But we don't know. Maybe the next day there may be more. This is not not say that this is.
But your lordship, one thing clear, beyond 7077 they are.
So therefore, that is just to ascertain that we are making this query that 7077 seems to be a constant. This may be a variable.
Maybe. Somebody because of this I could not join, allow me to join.
May have been allowed for some reason.
Some reason or other. That's it. Now, the next your lordship, 15th September 2020. Then your losses kindly come to page. It's an answer to clear na mane
Question number 8, এটা vital. Those who have absent,
English টা দাও, answer টা দাও.
answer.
Page answer at page
177.
177 may not be very legible. That's why I have prepared my lord two photocopies for your lordship because 7.
It's quite legible here with us.
All
15923.
15th September 2020.
15923. Quite legible.
My lord, দেয়াটা আছে আমাদের কাছে ঠিক আছে।
So our copy is good.
Yes.
Straight away come to the next page. 178. Your losses kindly come to
177.
Yes. My lord, the relevant page is lordship 178.
Yes. And what is this? Is also RTI.
RTI. Now, your lordship, the regarding point number 6, page 178. এরা কোথায় গেল? ওরা দুজন সবাই চলে গেল? 8624 candidates have been provisionally selected for the post of constable in West Bengal on the basis of recruitment process of 2020. Out of that, PVR and MER of 7100 candidates have been completed. Data regarding category-wise breakup is not maintained separately. This is first.
এটা আরেকটা মার্ক
বলছি
চেঞ্জ হয়ে যায়।
Then your lordship, next your lordship, point number 8. No appointment letter is issued without conducting satisfactory PVR and MER. Lord, I will harp on this, that therefore it is the determinative factor that the recruitment process doesn't come to an end. Then your lordship, point number 10. 6058 male and 994 female candidates are presently undergoing basic training. Then your lordship, regarding point number 13. My lord, what is that, my lord? The question was, your lordship, so for point number 13, my lord, I should take up your lordship the point,
What was the intention of the recruitment body?
my lord,
Whether to
the
fill up-
question was, what was the intention of the recruitment authorities to fill up all the vacancies or not? They say the purpose is to fill up the existing vacancies. Existing vacancies, my lord, according to me, the declared vacancies as per advertised.
Yes.
It is the facts.
হ্যাঁ এটাই facts।
So these are the facts before your lordships, my lord.
এবার তোমার
Facts are undisputed.
ট্রাইব্যুনালের অর্ডারটা দেখো, কারণ আমাদের কোনো রিপ্লাই রিজয়েন্ডার কিছুই হয়নি এট দ্য টাইম ফার্স্ট ইনস্ট্যান্সেই ডিসমিস করে দিয়েছে।
Now, I take your lordships, my lord, before placing the judgments, the order under challenge before your lordships. That's
So
a
the
page,
exact, what is the exact number of vacancies advertised?
that's
8632
8632
টোটাল।
total. That your lordships will get from the very first page of the advertisement. At page, I get your lordships, at page
Yes, we have got it.
61.
Both
your lordship
constable
total-
and lady constable put together.
You should add it, your lordships, to 860. Now, my lord, kindly come up, my lord, take up the judgment of the learned tribunal. 29th January 2023. 25, sorry. এই বছরই তো দিন। The last annexure probably a lawsuits will be.
No, we have the certified copy.
Yes. 29th, my lord, may I read it here? My lord, one thing before placing before this, my lord, I take you, my lord, I tell your losses certain things. This application was disposed of at the very interim stage.
At the?
Very interim stage. Well, I tell you losses the procedure because the tribunal is suffering heavily because of lack of the honorable members and judges. Then one member is continuing with the state administrative tribunal, and that's administrative member. Now, the point is that, my lord, when we file a, my lord, application, your losses, they will give that date 3, 4, 5 months after. Then your losses, this will come up for admission and interim also. This was at this stage, my lord, disposed of without calling for any affidavit. This is the facts. That's why, my lord, everybody submitted their document, but that's not the part of the pleading. But your losses stopped me from filing it before losses. That it was not the part of pleading, because at the motion admission stage this was done. And we are, my lord, being the candidates, we are eager to hear out the application. So that's why I could not, my lord, take out this. This is not the part of the record in such a sense.
Did not proceed. It did not proceed beyond the first date. That is what you are saying.
Not the first date, my lord. This was hard. Suppose I concluded, my lord, a particular day, then for their, my lord, reply or opposition, this was taken, my lord, again 2 months after. Then for my reply, because only one member, and that was done, my lord, in this way. So, my lord, that's why this is, my lord, this is at the, my lord, in.
Oh, so you had produced this, not recommended. This
I
you have.
placed, yes, Lord, not even, that's I take your losses.
Yes.
The matter is taken up by the single bench pursuant to the order contained in the notification dated circular. Since the above three original applications have been filed with the identical prayers and self-same cause of action involved in the same recruitment process, on consent of the parties, these matters heard analogously and disposed of by passing a common order. The applicants in these original applications have prayed for a direction to the respondent authorities to give appointment in the post of Constable Male 2020. The West Bengal Police Recruitment Board had published an advertisement in its website on 19th January 2020, inviting applications for recruitment to the post of Constable Male and Female. Mr. Sannal Learned Counsel for the appellants had submitted by presenting a booklet bearing memo dated such and such. The first page of the booklet shows the cut-off marks of both constable and lady constables under different social groups. The following pages appears to be the result of those candidates who were not successful in the recruitment process for the post of constable or lady constable of West Bengal Police 2020. Drawing attention to RTI replies, Mr. Sannal expresses that still 1547 vacancies are available, which were not filled up by the provisionally recommended candidates due to their failure in completing the formalities of medical and PVR. The RTI replied that on 11th August 2023 informs that a total number of 8624 candidates were provisionally selected, out of which a total of 7077 candidates have completed their formalities relating to medical examination and police verification role. It is submitted that as evident from the above information, out of 8624 candidates provisionally recommended, only 7074 have completed their medical and PVR formalities, thus leaving a vacancy of 1547 still to be filled up. It is further submitted that no appointment letter has been issued to 1547 provisionally recommended candidates. Therefore, as per well-settled law, these vacancies where no appointment letter has been issued should be filled up by those candidates who were earlier not recommended in the selection process. Hence, these 30 applicants in this application who had participated but not recommended in the first round of the same process should be given an opportunity and appointed to the post of constable against these vacancies. Then, my lord, the judgment cited referred to. Then you'll also their submissions respond.
Very much what you have submitted all has been noted.
Noted.
And then page 4, the second paragraph, the
Right.
tribunal proceeds to consider. Because all this you have submitted.
Yes.
একটা জিনিস শুধু দেখিয়ে বেটা প্লিজ একটা
From the submission of the learned counsels, page 4.
মিঠুন সরকার এসসি ক্যাটাগরিতে স্কোর হয়েছে 54.17, কাট অফ গেছে 54.25, মার্জিনাল কাট অফ, নট দ্যাট
Only one thing.
Yes.
Only it to consider.
না কনসিডার করিনি, এর মার্জিনাল 0.55 এ গেছে,
Just a minute, my lord.
লেস কাট অফ, কিন্তু আমাদের তো মার্জিনাল মার্কস।
And you'll also one thing I just point out factually, my lord, this is from order itself, page 2.
Yes.
Page 2, my lord, middle portion paragraph, Mr.
Yes.
Both of Pathak Banerjee.
Yes.
Now we lost, my lord, just I place this paragraph. For the presents a bunch of papers showing the category-wise cut-off marks for both constable and lady constables. Also the list of candidates who were not successful in the recruitment process. That I pointed out to your losses. After a random checking of the names in this list, the tribunal finds the applicants who were not recommended in the selection process had scored lesser than the cut-off marks set up by the recruitment board. For instance, appearing at serial number 6093, Otonupal, belonging to OBC B category, had scored 5692, whereas cut-off marks in the OBC B it was 5725.
This one marks.
This one. Then your lordship, similarly, appearing at serial number 1417, Mitun Sardar belonging to scheduled caste category had scored, your lordship, kindly note, 5.1754. 54.17. Whereas this category cut-off marks fixed by the board 54.25.
That is
No, I'm on that your loss.
admitted position that none of you were above the cut-off.
Provisionally merited.
Yes.
Now, my lord, is it the cut-off mark? I put a question to myself.
So therefore it all hinges whether it is final or not.
Exactly. This is not the,
The question remains the same whether by not mentioning final, which is at variance with the rule, they can say that this is final or not.
This is
And
one
the
thing.
other aspect is when the appointment is not issued, letter is not issued to all the persons against all the vacancies, can they say that it has finally concluded?
Well, all that I'm trying to here say, Your Lordship, this is Malad kindly see fraction of marks. That happens.
That is
But
very
Your Lordship,
common.
this is not cut-off marks. Cut-off marks, Malad always says at the time of advertisement, unless you secure 40,
Oh, no. Cut-off marks is fixed based on the performance in a competitive examination.
Malad, this is Your
A
Lordship.
cut-off
last
marks,
appointed candidate.
may be at 99 also.
Malad, that is last marks of the last appointed or selected
So
candidate.
therefore, the recruitment body, it sets a cut-off marks based on the number of candidates available in proportion that we have to select this many candidates. If there's a provision for waitlist, then that cut-off mark is slightly relaxed. If there is no provision for a waitlist, then that cut-off mark is sacrosanct. All those go above, they will be considered. All below will not.
But I'm not Malad taking any
A cut-off mark is never set in the advertisement.
No, I tell you, Lordship, Malad, cut-off
A
marks.
pass marks may be set, but a cut-off mark will not.
But cut-off marks, well, our division bench judgment, even Supreme Court judgment says there is a difference between cut-off marks and the last appointed candidate marks. Well, the panel says, well, suppose your lordship panel is consisting of 9,000 vacancies, 900. The last candidates who secured, that's the marks of the last appointed candidate. Well, that cannot be the cut-off mark.
No, that cannot be. But that is where they cut off the selection process. Therefore, that becomes the cut-off marks. His marks is not the cut-off marks, but no one below that mark is selected. Therefore, that becomes the cut-off. That is the place where they cut off the
That one
selection
can
process.
loosely say it, but in law, Mala, that should not be.
Let
I
us
tell you,
see.
losses, why I take your losses?
Because there is no issue of cut-off marks in
No,
your case.
I tell you losses, as because this is an issue becomes, if I do not get cut-off marks, I should be shown throw out. But if this is not a cut-off marks and it's a provisionally selected candidate's last mark, then I
Therefore, your whole entire thing hinges on whether it is a provisional list or not,
that's your losses.
whether it is final or not. In
Then
the
your
absence of any stipulation that there is going to be a wait list,
paragraph,
can it
then
be
your losses kindly come to page 4.
yes,
From the
second paragraph,
paragraph,
the
from the
tribunal's
submission
consideration.
of the learned counsel representing both sides, it has become crystal clear that applicants were not successful in the recruitment process for the post of constable, male constable conducted by the board. Such fact has neither been disputed nor made the core prayer in these applications. Well, this goes to the very first submission of ours. This goes against that. From the very few instances cited, it is not in dispute that all the applicants scored below the cut-off marks in the social categories. Here, Malad, I join an issue belonging to. However, the main thrust of the applicants is that since the number of seats are lying vacant, therefore these applicants be recommended in those. Malad, this is not our case made out like this. This is probably the learned judge has gone into like this. It is not convincing to the tribunal that how unsuccessful candidates. Malad, again, I am joining an issue. We are not unsuccessful. We may not be in the provisional list. Can claim for filling up the vacant post with their candidature. The plain and simple fact that they participated in the entire selection process but were unsuccessful. The question of filling up these vacancies with unsuccessful candidates in the same does not arise at all. Malad, this is like Malad, nowadays when the Supreme Court also says don't apply a judgment that stereotype manner. I am not unsuccessful. I rather, if your losses kindly see, I secured the Malad, I competed even, I called for the interview even on the basis of merit. The applicants who appeared before the Honorable High Court, which had heard and dismissed the petition with the following observations. These applications were not being heard, therefore we came up before this Honorable Court, but please fix a date and hear it out. When this observation, this is very, not even before the interim state. Indisputable, the petitioners have not been provisionally selected. From the contents of the report, it also does not appear that the resultant vacancies that may occur cannot be carried forward to the next recruitment process. The petitioner did not challenge the said notification and willingly participated in the recruitment process. Being unsuccessful, no indefeasible right has occurred in their favor. Then it is also clear.
You had approached the High Court also.
High Court, I tell your losses. I approached your losses when this was we filed the application. The application was given your losses. We prayed for interim order. The tribunal says it is fixed 6 months after. And they are going, we were anticipated that our case will be totally destroyed. We came up before this honorable. Ultimately, this was directed, hear out the application first. Because there was no very.
Where is that direction?
That's your lordship's.
No, where is the order of the High Court? Which
This is part of the petition. This is in the application itself. Just agree. So much. Just.
Page 170. Page 170.
ওই judgment
Page 170.
No. So the dated 2nd March 2024. Has you also got it? Page 170.
Yes.
2nd May. হ্যাঁ। 3 না 5 বলে যায়। হ্যাঁ। Drawing our attention to an order dated 20th March 2024 passed by the learned tribunal and an application filed by the petitioners praying for an early date of hearing in connection with original application preferred by them. Mr. Sandal appealing for the submission considering the petitioner's prayer for fixing an early date of hearing. Liberty was granted to them to mention the matter made returnable before a 2-member bench of admission hearing.
So it is without being influenced by any observation. We have seen.
That's your loss.
Yes.
Well, kindly see this situation, this tribunal.
Our page 4.
Page, again, your losses kindly come to page 4. It is also clear from the cited paragraph that the applicants had not challenged the recruitment. This is not Malad right. Willingly participated in the recruitment.
This is not right.
But this Malad reliance upon this observation while passing the judgment according to me is
No,
not.
but this is an admitted position. You have participated without any demur.
No, I have not. This is not an issue.
So
I have never questioned the recruitment. I am saying, as if the learned judge of the tribunal proceeds, I am unsuccessful, High Court dismissed it, and therefore everything became final. That's not Malad. Kindly see the language. The learned judge proceeds
right,
like
so
that.
it is ignoring the observation of the division bench that no,
Not,
any observation will not affect the outcome of
but
the
my submission, this has affected the mind of the judge.
because he says that be that as it may, he says whatever the High Court has directed, I am now considering. He has taken note of. Just read the entire paragraph.
The honorable High Court's observation is that being unsuccessful in no indefeasible right.
Now next line.
Be that as it is, the
Yes.
tribunal has properly examined the matter. Now your losses, Malad, suppose if your losses forms an opinion against me in first 3 lines,
Yes.
then even if your losses write that, Malad, your losses, Malad, oblivious of that observation.
The tribunal records its own satisfaction. It does not dispose of the matter by
In
by
the light
record.
of the facts in this case and has come to this conclusion that applicants being unsuccessful
Yes.
in the recruitment process cannot turn around and question the very legality of the recruitment process. Malad, I have not also questioned the recruitment of the candidates who have been appointed. Kindly mind it, your loss. I am not the recruit to question the legality process. Claim their candidature in filling up the vacant post. The tribunal is also satisfied that the recruitment board did not commit an error in deciding these vacancies would be carried forward to the next year's selection process. What is that finding? I do not know, Malad. In similar case, the Honorable Supreme Court of India recorded the following observation. We are of the view that the applicant cannot claim appointment on unfilled vacancy being next below the candidate in the merit list. If the submissions on behalf of the appellant is accepted in that case, it will lead to providing for preparation of a waiting list, which otherwise not permissible as per sub-rule 5, rule 6. Now I will take your losses to this judgment. If the
So
same,
according to you, there is no basis for the tribunal to conclude that the remaining vacancies are to have been carried over to the next recruitment process.
No document, no affidavit.
Come to page 164 of your brief.
160. That's RTI reply.
Yes.
And I know that your losses.
This was before the tribunal.
Exactly, loss. This will be from
Point number 7. Sorry, no. Yes, point number 7.
Malad, your losses referred to page
164 and extra J. Annexure J 164, point number 7.
No, no.
11th August 2020.
এই যে 160 দাঁড়ান বাবা। একটু দাঁড়ান দাঁড়ান।
তিনটে রিট পিটিশন না যার জন্য গোলমাল হয়ে যাচ্ছে। Point number 8. The resultant vacancies are filled up in the next recruitment process as 100-point roster.
So
So,
this was before the tribunal. It's
Sir,
not
but-
baseless.
But where is
You
the,
have brought this before the tribunal.
but where is that case that this was carried forward?
That is what it is saying. In the next recruitment process means carried forward.
This, they say
There's
normally.
two different ways of saying the same thing. So you please read the response to point number 7.
The resultant vacancies are filled up in the
Next recruitment process. So that means carried forward. What else? Only carried forward vacancies are to be considered in the next vacancy, in the next recruitment.
Exactly, Lord. Here again points comes up.
Yes.
If the selection is not concluded, how can it be carried forward?
So therefore, your entire thing hinges on whether it is provisional or final.
Exactly. That's all.
That is the sheet anchor of your case.
দেখালে কি করে দেখাবো records নয়. Now therefore your losses kindly let us again to the judgment. The quoted portion. If the same is permitted in that case, it will be directing the respondents to act contrary to the statutory provisions. Therefore, the High Court has not committed an error in refusing to appoint the appellant to the post which remained unfilled due to one of the selected candidates in the final selection list not appearing for counseling. The impugned judgment and order passed by the High Court is absolutely in consonance with the relevant statutory provisions, which we agree. In view of the prayers of the applicant have no merit and disposed of. Kindly see, the learned tribunal did not discuss about our judgment. We have cited. And here, your lordships, there is a specific rule I will show to your lordships.
So there it was a final select list.
Yes.
This is
Final
what you are
select
saying.
list and rule says, I will take you lordships the entire because one paragraph has been taken.
No, the rule here also says whether the advertisement there says or not. The rule
Final merit.
here, the rule here also the rule says
Final merit
a
list.
final merit list. But you are saying because final is missing in the advertisement, therefore it has to be considered as a not final.
Exactly. That's because rule will prevail always. Even there is any contradiction between rule and advertisement, so because the rule will prevail.
But the rule says it is a final merit list.
Final merit.
The rule here also says it is a final merit. There is no merit list to be prepared after this. Though the way it is contemplating, the rule is contemplating the recruitment process, that once a merit list is finalized, it is finalized. Based on that, appointment may be provisional. Some may go through the process of verification, some may not.
But here the rule is not, sir.
No, here it is like that only.
No, here your losses rule says final merit list
Of provisionally. So therefore, merit list is final. But it is provisional because they all may not join or they all may not succeed in the next process. But merit, we will not go below this. That is the clear intention of the rule. Now, because word final is missing in the advertisement, can you derive any advantage due to that? That is the issue.
And how they proceeded with your losses.
That is how they have proceeded.
How they proceeded with both the test, somebody didn't turn up. Here, the Supreme Court intervenes how it is to be interpreted.
Let us see.
That's it. এই judgment. No. না এটা নয়, এটা রাখো। এই দুটো জজ শ্রীকান্ত রয় দুটো নাম একটা আছে দিস ইজ মাই লর্ড Shrikant Roy versus State of Jharkhand. This was reported in 2017, volume 1 SCC, page 457. I give you losses the photocopies. Here your lordships dispute with regard to what is the meaning of post and vacancy, and then the dispute in regard to the quota of the direct recruitee and promotory of the district judge. The losses, তোমার আছে এখানে? তো দেবো একটা copy?
2017 তো 17-14 এসেছি
এটা 1 এসেছে, এটা কোথা থেকে করে সুপ্রিম টুডে থেকে বার করেছে। শ্রীকান্ত রয়? না
না না
ওটা তো অন্য জায়গা।
মঞ্জু পারবেন
এইটা নাও, একটা কপি দাও না দাদাকে। এ নাও। আচ্ছা
এটা কি
ওই জায়গায় যেটা প্লেস করছি, এটা অন্য জায়গা। Now your losses will not take into consideration paragraph 20. Paragraph 19 says the High Court has overlooked the distinction of post and vacancy. Paragraph 18
এটা দেখাচ্ছি
paragraph 18 and virtually in the paragraph 20. But may I read with your losses? Paragraph 18 first. Page your losses, that's page 12 from, at the top right hand side. Paragraph 18. Considering the fact that no vacancy existed in the quota of direct recruit as on 30th August 2008, the read petitioners, respondent numbers 4 to 11 in the leading appeal, who could participate in the selection process for direct recruit alone and not by way of a promotion through limited competitive examination, had no locus standi to challenge the selection process of 2008. Then, Malak, the post and vacancy, what does it mean? Court dealt with. and said that the High Court overlooked this distinction. Then paragraph 20. Having said this, we must follow, it must follow that the selection process of 2008, which has been completed pursuant to the liberty given by this court by an interim order, is proper and has become final. On these findings, the challenge in the companion writ petitions to the selection process commenced for the year 2010 does not merit interference. In that, the vacancy position as on the date of the notification, 4th November 2010, for commencing selection process in 2010, were only up to 8 vacancies for for appointment by direct recruitment from the bar. None of the writ petitioners before this court claimed to be within the first 8 merit list candidates. The petitioners were placed at serial number 9 onwards. The first 8 candidates having been appointed, the selection process of 2010 would get exhausted and considered as complete. Merely because the name of the writ petitioners appear in the selection list do not require indefeasible right in getting appointed. The vacancy have to be filled up in conformity with the extant regulations. The selection process in which the writ petitioners participated was commenced on the basis of the stated notification of 8 notified vacancies, and appointments have been made of meritorious candidates. That selection process must be treated as having come to an end. The fact that the notification for subsequent selection process commenced after 2010, issued by the High Court, notifying different or higher number of posts for direct recruitment can be of no avail to the selection process of 2010. That changed position in the ascribable to the subsequent period on the basis of availability of posts for direct recruits, not for selection process of 2010. Similarly, the fact that one candidate amongst the appointed 8 candidates after due selection subsequently resigned, no right can accrue to the writ petitioners on completion of the selection process of 2010. Reliance placed on Rule 21, which requires preparation of select list and to notify the same or to remain valid for 1 year from the date of being notified. It is also inapposite. That is not a rule mandating preparation of a wet list of the selected candidates. No express provision for retaining the select list as wait list for 1 year has been brought to our notice. On the other hand, the effect of Rule 22 is that once the names of the candidates from the notified select list are recommended to the government proportionate to the vacancies available for appointment, and conjunctive recommended candidates are so appointed, or on expiry of 1 year from notifying the select list, whichever is earlier, the select list would become ineffective for the subject selection process. And for that, the selection process is complete. Here, Malad, this is not the situation. Malad, the provisional select list doesn't have any time limit. As because this is not a final list. Now, Malad, the number of candidates were not appointed at all. They were only recommended for testing and undergoing the test. So if they did not appear even for test, well, those vacancies, the remaining vacancies cannot be said to be the filled up or the selection process comes to an end. For this proposition, I am citing this judgment. এবার আমাদের জাজমেন্ট বলো মুঞ্জা পারবি all yeah this based on facts but therefore because your loss is well suppose your loss I that your loss is right, but here your loss is all that I'm saying when the selection process comes to an end. Madam, I'm not match. Madam, that I will subsequently I will try to show. But here, madam, because madam, according to me, the Supreme Court, the Honorable Supreme Court was, madam, didn't have the opportunity to go to that extent. Madam, the ratio is that when the selection process comes to an end. If the selection process, all the appointed candidates are appointed, or your losses, even letters of appointment are issued, even then. Nine and 10 onwards. Here, well, here, well, I think your losses, factually, your losses can, in every case, your losses will be having some distinguishing feature. But this, that does. But here, as I have tried to search out and read the book, that the selection process starts from advertisement, say, it ends either on the expiry of the panel or appointments are issued. That's the settled law. Even if I am on the select list, but I was not appointed in the meantime, the panel expired, the lifetime of the panel. I didn't have any right. Just. এই জজমেন্টটা এসছে 2010 এই আরেকটা কত সহজিত দ্বিতীয়টা রূপার হয় না নাকিরা এসছে প্যারাগ্রাফ সব মিলবে না না I'm just taking a sense. Well, here on the same proposition, because my endeavor to convince your lordships. এটার মধ্যে বার করতে দেখি এটা হচ্ছে বাকিরা দুটো চারটে সেট আছে 14 এটা আমাকে একটা দিয়ে রাখি দেন This is Rekha Roy versus High Court of Delhi. This is reported in 2010. Rakhi Roy. Rakhi Roy. এত জিনিস দেন এগুলো 10-2 SCC page 637. Here you'll see the main dispute was whether the authority can whether the authority can appoint exceeding the number of declared vacancies. Well, a settled law cannot. But while dealing with the Supreme Court, observe what your losses can say. Your losses kindly, I will look at the judgment, then I will take your losses to the relevant passage. No, I don't think so. Your losses kindly will look at this. No, here your losses point is that Supreme Court went to the extent, suppose 10 vacancies declared. As soon as the 10 vacancy appointed, you cannot proceed further authority because selection process comes to an end. So this is not an obiter, madam. Obiter, madam, there was no issue at all. It's part of the issue. Madam, kindly see paragraph 14 only. I think, madam, that will suffice. 1.4. In view of the above, the law can be summarized to this effect, that any appointment made beyond the number of vacancies advertised is without jurisdiction, being violative of Article 14 and 16(1) of the Constitution of India. Thus, a nullity inexecutable and unenforceable. Then, in case the vacancy is notified, stand filled up, process of selection comes to an end. Waiting list, etc., cannot be used as a reservoir to fill up the vacancy which comes into existence after the issuance of the notification. Because here the issue was those vacancies came after the issuance of the notification, they filled up. The unexhausted select list becomes meaningless and cannot be placed in service. So, vacancies declared, appointed, I can accept your losses that appointment letters issued didn't join. Even then, your losses I do not have. But no appointment letter issued, that cannot be. Well, this was placed before the learned tribunal, this judgment. 2017 14 SCC, page 79, page 797. Well, there was a certain government orders, all that. Your losses, kindly have a just cursory looking up to paragraph 7, then I will read with your losses. Second of it. From paragraph 8 is important. Eight onwards, that would be relevant. First, just may I read with you. Since the judgment of the High Court is based on government memorandum GOM 81 dated 22nd February 1997, we may deal with the said government detail. In the said GOM, the practice of having a long waiting list has been deprecated. We have carefully gone through the GOM's concern. These GOMs has been issued in certain peculiar circumstances. It appears that a common test was held for a number of services comprised in Group 1, which includes Deputy Collector, Deputy Superintendent of Police, Commercial Tax Officer, Regional Transport Officers, District Panchayat Officers, District Register, etc. Obviously, people higher up in merit chose to occupy the more coveted post of Deputy Collector, Deputy Superintendent of Police, etc. A waiting list was also prepared. The waiting list started after the last selected candidate. That is to say, if the post of district register was the last coveted post, the waiting list would start after this post. If some candidates higher up in the merit list did not join one of the higher posts, then the next person next in the waiting list would be offered upon. This led to an anomalous situation where a person having a higher marks would get the post of Deputy Superintendent of Police, but a person much below him in the merit list, but at serial number 1 and 2 of the waiting list, would be appointed to the post of Deputy Collector, become some person had not joined the post of Deputy Collector and there was a vacancy in the said circle. Those selected candidates who had joined on the less coveted post, say any assistant account officers, district register, etc., claim that before offering the post to those on the waiting list, they should be permitted to change their service. This led to a large number of cases being filed, and it is in this context that GOMS was issued. Reliance has been placed by the appellants on paras 8 and 9 of the GO. Relevant portions reads as follows. 8. According to these rules, in a recruitment year, against number of notified vacancies, selection shall be made only to the equal number of posts notified, and there shall be no waiting list. In other words, in a recruitment year after selection of the candidates and after issue of the appointment orders, if the candidate fails to join duty within the stipulated period, that vacancy shall be notified again in the recruitment year. This alienates the system of preparing waiting list for fallout vacancies. 9. Therefore, the government, after careful examination, has agreed with the proposal of the Andhra Pradesh Public Service Commission and accordingly directs that henceforth the list of candidates approved or selected by the Andhra Pradesh Public Service Commission shall be equal in the number of vacancies only, including those for reserved communities categories notified by the unit officers. The fallout vacancies, if any, due to relinquishment and non-joining of selected candidates shall be notified on the next week. According to us, the High Court has totally misconstrued the above GOMS. The portion of GOMS quoted above clearly lays down that there shall be no waiting list and the selection may be made equal to the number of posts notified. The purpose was that the vacancies arising due to people leaving those posts must be filled up by subsequent. But kindly see the intention. This is the rules, Mala Service. I am subsequent rules. And if it was after selection of the candidates and after issue of appointment, if the candidate fails to join within the stipulated period, the vacancy should be notified. This was placed before the learned tribunal, but learned tribunal didn't dealt on this how it is to be
Down. The government had consciously notified a relaxation. That was a recruitment process. One person was emerging as number 2 in respect of 3 corporations. Therefore, he could not have joined all 3 corporations. Coming to face with such a fact and circumstance, the government said, yes, we are required to work it lower because that number 2 position will remain vacant. So the person who is at number 3 in the other 3 corporations, he will become number 2. Here there is no such decision of the government that we are going to operate it downwards or we are going to allow others also to join because of this unique and special circumstance. The Supreme Court has taken note of it, that it is a unique and special circumstance.
But your losses, what is the law laid down?
So
I think your loss.
yes.
Paragraph 9.
You see paragraph 10.
Paragraph 10.
What is the government's notification? I am to invite attention of the above subject and reference cited and inform that the government, after careful examination of the matter, hereby relaxes the provision as a special case under the circumstances of calling for candidates on basis of verification. So there was a conscious decision of the government.
Finally, your losses take paragraph 14. I may read with your losses.
Yes.
This was the case dealt with, but
yes,
what is the law laid down Supreme Court says?
That yes.
Paragraph 13, I'm with your losses. This is specific provision of 8 and 9 of that case. Now, kindly see. We may also add that the High Court did not note an earlier division bench judgment of the Andhra Pradesh High Court, wherein the High Court had correctly interpreted GOMS. Kindly see. The process of recruitment starts from the date of notifying the vacancies, attains finality with the act of issuing appointment order, offering the post to the selected candidates. That's what I'm trying to say, your losses. What is the service jurisprudence says?
Yes.
This is the point, your lordship. Unless this is done, this is I know, this is a specific case on the particular government order. But what is the law? Law says it is the vacancy starts, appointment letter issued, goes, and that thing comes to an end. Or, my lord, on the expiry of the panel, if the statutory limits has been fixed by the statute of the rules. This is the point, your losses in that. Now you'll well, this was placed before the learned tribunal. So I place it. Of course, my lord, this is one of the single judge's judgment of the Telangana High Court.
Why do you want to place that?
See, persuasive force if your losses. If I can, it can persuade
You
your
have
loss.
given 3. It must be reiterating the same proposition.
Selection process, my lord.
So therefore, multiple judgments are not
Or-
required for the
and
same, unless there is something else that you want to show. If
No,
the
that's
same
not
thing,
Not
not
only
required.
one thing, my lord.
You have
The
shown
judgment-
3 Supreme Court. Why to go on?
No, only the judgment the tribunal recorded. That I am.
Yes,
Munna, ওটা কি জানো?
but that you have just shown.
No.
This
That's
was-
your lordship. We placed the learned tribunal quoted the paragraph. And
Punja Praveen is you have just cited.
yes, but here your lordship Bhalumati Satish Babu.
Okay,
That's your lordship the learned tribunal paragraph.
that must have been placed by the
by
state.
the ওটা কপি দাও জোসেফ
এক্সট্রা কপি নেই কিন্তু তুমি ওই এখান থেকেই বলে দাও
কোথা থেকে বলবো না না
এখান
এটা থেকে
থেকে
বলবো
আচ্ছা আচ্ছা
আরেকটা কপি হুম
দে
2473 of 2022.
Exact. But kindly consider how this.
এটা ফাইনাল সিলেকশন লিস্ট বেরিয়ে গেছিল
But I will be only the relevant portion I will show. But, if your lordships, the second page, the paragraph, continuing paragraphs, last 4 lines. ওই তোমাদের কি আছে, ওটা কি বাবু সতীশ
আরে
বাবু।
আপনারা দেখেছিলেন তো ওটা
As per sub-rule 5 of Rule 6, the number of candidates selected shall not be more than the number of vacancies notified. It is also specifically provided that there shall be no waiting list and posts, if any, unfilled for any reason whatsoever, shall be carried forward for future recruitment. The specific rules your lordship.
So there is no such stipulation.
No such stipulation. Then your lordships, page 4, paragraph 3.1.
3.1 4.2
Yeah. 3.1, it is submitted as per rule 16.5 of sub-rules of rules 2012. The number of vacancies selected shall not be more than number of vacancies notified. Hence, in the present case, the selection was incomplete since one of the candidates did not turn up for counseling and receiving the order of selection.
So there you are trying to draw a parallel.
I will show the ultimately how.
We'll see.
The councils are over, he's here. One is for the order. And the other one? একটা ফিক্সড রয়েছে ফর কালচার জন্য ওনার অপশন থাকবে
Item number 5, continue. Well, with the leave of this, your lordship's my lord, I am placing the references. Paragraph number 3.1. 3.1. The judgment, Bhallampati Satish Babu. Yes. It is submitted that as per the rules 16.5 of the rule to 2012, the number of the candidates selected shall not be more than the number of the vacancy notified. This is a settled position. Hence, in the present case, the selection was incomplete since one of the candidates did not turn up for counseling and receiving the order of selection. Thereafter, the appellant being the next candidate as merit, namely at 34th position, was entitled to appointment out of 33 notified vacancies. As one of the candidates did not turn up even for counseling and the vacancy had to be filled up by the next meritorious candidate, namely the appellant hearing. That was our contention. Now, 3.2, it is submitted as per guidelines. The verification has to be done by the candidate in the provisional select list, and finally, after counseling, final list will have to be published. Here in the selection process, no final list has been published. Now, kindly come to paragraph 3.3. It is further submitted that rule 16.5 of the rule 2012 provides preparation of the selection list, and it is submitted that as per the said rules, the selection has to be made equal to the number of vacancies. However, there will be no waiting list, and if there is any vacancy due to some other reason, then that will be carried forward. It is submitted that the situation contemplated in the rule is like resignation, non-joining after getting an appointment. After getting an appointment, untimely death after joining, etc. It is submitted that, however, in the present case, there was no appointment letter issued to one of the selected candidates, and hence the selection was not complete. It is submitted on a fair, meaningful, and combined reading of the rule. Along with the guideline, it shows that the final selection list could have been prepared and finalized only after verification and counseling. That number of selected candidates cannot exceed the total number of the vacancies. I kindly come to paragraph 4.1 thereafter. It is primarily submitted by such and such learned counsel. Yes. Please. That's why this judgment is not applicable in our case.
Therefore, this is not applicable. Oh,
Not
because
applicable.
there was a question or there was a final, but here there is no final.
I kindly see the learned counsel 4.1 appearing on behalf of the state that it in the present case the state has followed the detailed procedure provided under Rule 8, which reads as follows. What was the rule? Roman 1, the rule 8A, a provisional list vacancies is to be notified and the venue is to be fixed for verification of candidates. Roman 2, after rules 8A and 8D to 8D provide the procedure of verification. In terms of rule 80, the provisional list is required to be read on in case of any candidate is found to be ineligible in the process envisaged under rule 8A to 8D. Under Rule 8F, a further verification is envisaged in respect of such candidate who may have been included as a result of revision of the provisional list under 8A to 80. Roman 5, Rule 8G envisages the publication of a final selection.
So this is absent in the advertisement. This is absent in the
advertisement. That's why that is not applicable in our case.
This is absent in the advertisement. Very well. Yes.
And one provisions of one observation has to be considered that after medical and after counseling, a final list should be published.
No, so here also there is a final list, final merit list under the rule, but in the advertisement it is absent.
Absent. That's all.
Yes, sir.
Provisional list is published.
Now, can you see page 156? But the recruitment rules. Rule 11. Have you not got page 156?
Yes, final merit list.
Yeah. No, preparation of merit list.
Yes.
The final merit list of probationary selected candidates.
Final merit list.
Well, yeah, just a minute. Candidates shall be prepared on the basis of the total marks obtained by the candidates in the written test and interview. Then verification of the testimony. All the candidates professionally shortlisted or the interview be asked to appear for the verification of all the documents. The procedure, date, and venue of the verification will be decided by the board. Then, Rule 13. Verification and character of antecedents. All provisionally selected candidates shall be required to fill up verification role which shall thoroughly inquired by the concerned. Then, medical exemption. All provisionally selected candidates will send for medical exemption at the state government hospital. The selected candidates shall be board sarkanja. Then, kindly see, is there any provisions that what about 8,000 something total number of vacancy? 1,500 or 1,700 something did not turn up.
1,500.
Yes. But did not turn up till now. Because sometimes verification role comes later. Because somebody is staying in Bengal, sometimes shifted in Bihar or Odisha.
Anywhere, yes.
Anywhere. Then we shall have to verify the records. It will take some time because of 2023. Now, as soon as 2023 notification issued, we have forwarded the remaining unfilled vacancy to the next vacancy. For the migrant fund clients, so far as Ankita Goswami, she was not selected. She got 44.75 in a final written test and marks obtained in interview 11.33. And the other candidates got higher marks in a written examinations. Then assembly Itu Midda 47.25, marks in interview 8.5, 55.7.
Where is that?
Where
is her name?
Nothing. That is
Ankita Goswami is the second last candidate.
Yes.
In the list.
Now, Ankita Goswami was not selected.
This is not recommended.
He was not recommended. But a first provisional recommendation. First recommendations will go to the department. Then they will issue the VR form. Then after VR form coming, they will send for medical exemption. After medical exemptions, it was found fit for duty.
So why this not recommended list was published?
But that is the practically this is the final list.
Why this not recommended list was published?
Not recommended list, but so that they are informed that your name has not been recommended for appointment. But as soon as selection is made, about 8,264, 7,077 reported, and remaining 1,547 remain vacant.
And the cutoff was also notified on 19/4/23.
Yes.
Same day on which this not recommended list has been published.
With the provisional list.
With the provisional list. But if I today recommend minor funds clients to be appointed, then what will happen? Already you have notified in 2023 vacancies.
No, they are not seeking appointment. They want consideration.
Consideration under consideration must be with the zone of consideration.
So therefore, there is no question of giving them appointment. They are here because they say 1,500 vacancies have remained You consider which of us are eligible, and then if we are eligible, you appoint us. They are not saying you give us appointment.
But the same rule came up for consideration before this honorable court on 21st August 2023 before a division bench of this honorable court. Mana kindly see paragraph 10, 16, 17, 18 and 9, 20. কপি নেই আচ্ছা দাঁড়া আমার কাছে এখানে বার করুন
ঠিক আছে
paragraph 10 can see. Learned senior advocate appearing for the petitioners referring to page 160 of the writ petition, being a notice issued by the West Bengal Police Recruitment in the website submits that the person selected was subsequently substituted and therefore the considering the petitioner successful candidate versus they should be given appointment. Learned senior advocate submits that the 3,000 vacancies were declared in the selection process. He refers to the notification dated 21st July 19 and submits that as the notification governed the selection process in this case. He refers to paragraph 7 of the notification that rule 5 of the existing rule was substituted. He submits that in terms of the such and such. Then Mala kindly see paragraph 12. Paragraph 15.
Paragraph 15. না না অন্য
Paragraph 13 will say, we are concerned with the selection process initiated by the Police Recruitment Board by the advertisement published in the website. Petitioner participated in the selection process without any demur. Petitioner did not feature in the select list of the candidates on August 2022 or the revised select list on September 22. Petitioner therefore approached the tribunal for seeking a direction that should be given appointment. The recruitment process is governed by the notification dated sub-rule 5 the recruitment process. Preparation of merit list, verification of the testimonials, character antecedent, medical exams, etc. Merit list, the final merit list of provisional state candidates shall be prepared on the basis of the total marks obtained in the final merit written test and interview. WBS shall have the discretion to fix qualifying marks in a preliminary written test and data. West Bengal Police Recruitment exercise discretion in the present selection process, preparing a select list of 3,000 candidates for 3,000 declared vacancies. List of candidates was initially published on August 2022, thereafter revised on September 2022. None of the petitioners featured in the either in the select list published on October or to the next revised list on September. West Bengal Police Recruitment in their wisdom took a number of obtained by the last candidate in the select list as the cut-off number of the person's consideration of the candidature of a person in the selection process. Nothing on place on record suggests that such action of the West Bengal Police Recruitment Board is dehotes the published recruitment rules or violation of the Rule 5 of the quoted above. Rather, the stand taken by the police recruitment is consonant with the rule. Then, after considering the judgment, kindly see another judgment of the Supreme Court.
And you are not relying on Velampati.
I am relying also on this proposition of law. Kindly see 2010 6 SSC page 37. 2010 volume 6 SSC page 37. 777.
Page 337.
No. 777.
777.
Paragraph 11. 777. State of Odisha versus Rajkeshwar Nanda.
Oh, this has been reported.
Reported.
Velampati is now reported.
Paragraph 16. Paragraph 16. Can you see paragraph 15? Paragraph 14, can you see? A person whose name appears in the selected does not acquire an individual right of appointment. Employment at the list is the condition of eligibility for the purpose of appointment and by itself does not amount to selection or create a vested right to be
Paragraph 14.
14, Maharaj.
It starts with the guidelines have been issued.
No, a person has been, the 2010 volume 6 SCG page,
Huh?
2010 volume,
You have given us 22 volume 13 SCC.
no, sorry, madam.
তোমরা আমাকে রাখো তুমি এই তোমার প্রবলেম হচ্ছে ভালো দুনিয়া দেখছো না
One of us you have given the correct judgment. One of us you have given us the wrong judgment.
Paragraph 14.
Yes.
Honorable Lordship got it.
Paragraph 14.
Yes. A person whose name appears in the select list does not acquire any indivisible right of permanent employment at the best is condition of eligibility for the purpose of appointment and itself does not amount to selection or create a vested right to be appointed. The vacancies have to be filled up as per statutory rules and conformity with the constitutional mandate. A constitutional bench in case of Sankarasan Das versus Union held that appearance of the name of the candidate in the select list does not give right to appointment. Mere inclusion in the candidate's name in the select list does not confer right to be selected even if some of the remain unfilled. Kindly see, if some of the vacancies remains unfilled, a candidate's concerned cannot claim that he has been given hostile discrimination. Then a select list cannot be treated as reservoir for the purpose of appointment. The vacancy can be filled up taking the names from that list as and when it is required. It is a settled proposition that if no relief can be granted to the candidate, if approach the court after expiry of the select list, if selection process is over, select list has expired and appointments have been made, no relief will be granted by the court at the belated stage. Now, in 2023, we have published an advisement selection process has started. Now in 2025, if we are considered their case, then we should have to re-advertise the post. Selection process started. Remaining vacancy you have carry forwarded to the next vacancy. Now the language is provisional list and final merit list. According to my humble submissions, the language quoted in the rules, provisional list. We have treated this provisional list as soon as everything is complete, it becomes the final. If somebody cannot join after fully verifications or did not turn up,
Yes.
and the same thing, I think Mr. Sandalar Press 2017-14 SSC 797, paragraph 9 to 14. Monju Parveen versus State of Telangana.
Which one? Munja Parveen. Munja Parveen.
Yes. Answer is the last question. Quoting from the state of Andhra Pradesh Bagana of the Rasam. Yeah. Now, my lord, you will also consider further.
Which one? In this Munja Parveen, which paragraph?
Paragraph 14 practically last.
All
Offering appointment letter. We have given offer.
This is incorrect.
We are offered appointment, that is so why. Police verification and medical exemption. These have been issued, but they did not turn up.
Then appointment. Where is the appointment? Show any appointment letter to the court.
Appointment letter issued when? When he has submitted a police verification report and a medical report. Then the appointment letter is issued.
And then
That is the difference.
what you say and what you follow are different.
আমাদের কাছে লিস্ট আছে 1547 তাদের লিস্ট
Have I appointed anyone from the list prepared on 8,000 something? No. Answer is no. If the candidates who did not turn up or VR report has not returned, but can we take his candidature for the appointment? But the answer will be negative. Because we have forwarded this vacancy to the next to the 2023 vacancy.
Yes.
Then we'll enter selection process of 2023 to revisit it, which is not permissible. No, we have already notified.
Notified দিয়ে বসে আছো যেমন বসে থাকো
And 2023 is also complete.
No. And 25 also started because of the judgment of the division bench in OBC's matter.
Without completing 23, 25 has started.
Yeah, 25 started, but stopped because of the judgment of.
No, what happened to 23?
23 in the meantime started. In the meantime, OBC judgment came. Then we stopped there. 23 is a lady constable. Constable or lady constable? Both. In 24, 25, lady constable, constable. 23 only lady constable. But because of this, we got the information that OBC.
OBC তো 24 এ judgment দিয়েছে
24th August.
Then what about 23?
23.
That should come up before the court properly. হচ্ছে না
You are going to be replying. Why do you have to interject? Yes. Yes, that's all.
Yes.
Yes. Yes, Mr. Sanyal.
Shannon.
On these submissions, facts would be cleared before your lawsuits because there was no affidavit before the learned tribunal. Well, 23 notification is there for lady constable, but there was no process further except notification. This is only lady constable. Therefore, the male was not carried forward. Question doesn't arise at all.
Yes.
Now, they are showing the judgment of the our division bench in regard to cancellation of OBC certificate, all that. That's
They have not shown.
No, they're saying that OBC judgment because.
Still, at least speaking for myself, I don't know what is that issue.
That's now I'm saying just since that
is not arising here.
Now 24 your lordships, male, female both. Only application
female and 23 male and female.
I to bolchi. But no application received, no proceedings.
23 that was only for lady constable.
Lady constable.
But beyond application, nothing has happened.
Nothing. Now here your lordships will not at least no documents is produced either before the tribunal or learned tribunal that this was carried forward. But this is factual.
That see, this is a fact apparent from your own documents.
Well, that's
you are relying upon a document from question 3 to 7. You rely on 3, 4, 7 is the answer where they say it is already.
But I will not repeat your lordship. That's only what they do. Not said that in this year they have.
No, no, no. You read again 164, page 164.
Question number 7.
Because all your queries are specific to that recruitment process. You are not asking anything in general.
Point number 7, the resultant vacancy.
Yes.
I got 2 questions. First, what does it mean by the resultant vacancy?
Read it first, then you make your interpretation.
Are filled up in the recruitment process as per 100-point roster.
Yes.
And next? Next, your lordship, the result has already been published.
No, 164.
164.
There is something more. I remember. In the next recruitment process.
Yes, in the next recruitment process.
Yes.
My lord, our whole argument was, my lord,
In the
this
next
is not the resultant vacancies at all, because recruitment process did not terminate. Resultant vacancies only will be on
See, I am unable to appreciate your query to point number 7. I have not been able to see what was your query.
That's your losses, page 160.
That's
All
why
your
I'm
losses,
saying.
Bengal.
That's why I'm saying.
Bengal.
I am unable to appreciate. You have not been kind to me.
Should we come give it your losses in translation from our official translation?
Whatever you should.
I give you within 1 or 2.
When you are addressing me, please
So
be
that-
kind to me. I want to know. I want to understand.
All that is saying, my lord, if I translate, if you allow me, that what would be the happen in respect of the vacancies where the candidates did not fill up the form at all.
Yes, and this is in relation to 8632.
8632.
This is in relation to 8632 for this recruitment process,
Exactly.
not a general.
Exactly. But this is not the resultant vacancies. That's my point. Resultant vacancies, my lord.
That is
That's
whatever
our whole
they,
case, my lord.
they are responding to your query. They say resultant does not make it different from what you are asking. Or you would have gone in appeal before the appellate authority that I have not been provided the information that I required.
My lord, yes,
So
lord,
whatever information you required, they gave it to you, you relied on that.
I placed it.
Now there is no question of interpreting that it meant something else. It was a response to your query under a statutory provision which obligates them to give a response, and if they don't, you had the remedy. So therefore they cannot be at variance. Your query and the response cannot be at variance. If it was at variance, you would have approached the appellate tribunal, which you did not.
I did not.
Therefore, it is a response to this very query.
I
Yes.
bow down to that.
And resultant, expression resultant does not make it any different. Resultant means what you have asked, those who have not filled up.
Those not
So
filled.
as a result, resultant, what is wrong in saying resultant?
Now your losses, my lord, those who have not filled up the form.
Yes, so as a result, resultant. What is wrong with that?
Now, if your
How
losses,
does it mean anything different?
even your loss, now your losses, the questions comes out.
Yes.
If the selection doesn't, my lord, come to an end in respect
Therefore, that you have been repeatedly
that's
saying.
your loss. That's the point.
That you have been repeatedly saying.
Now, that's our case before the tribunal.
Yes.
Now, this judgment, your losses, my learned friend cited, Anirban Roy Chaudhary. Lord, your losses, this is not address the point we have raised. This was not an kindly consider, my lord, judgment should be applied on the basis of the facts. This
Yes.
is not any. And similarly, your lordships consider the judgment, my lord, placed by them, Vallampati. Vallampati, your lordships.
Yes.
Vallampati also your losses, if your losses, I have placed it in
Vallampati, yes.
your losses. The Vallam,
Can we refer to the reported citation? It will be better.
Vallampati.
It is reported. You have given us a copy.
Not a reported copy, I think just unreported copy. We have
No,
given.
reportable.
No, no, reportable. তুমি reported দিয়েছো তো।
No.
Sometimes there is a difference in the
Different,
paragraph.
different.
In fact, very often there is a difference. No, 2213 is. So here 3.1 remains 3.1.
I've got a copy of the Vallampati.
3.1 remains 3.1. It is good.
Paragraph 20 and 21.
Paragraphing is the same.
Same.
Yes.
No,
Now, your losses kindly consider.
Reported.
Yes,
What
we
was-
have it. Give it to him if you have
No,
extra.
on the last occasion I placed before losses.
No, if you have an extra copy of the reported one, you give it to him to bring coherence into the proceedings. It appears to be the same.
Same. Now your
appears-
losses kindly 7.3.
Yes.
I take your losses over the 7.3 as it is.
You had relied on 3.1.
3.1. Then your losses will find. Oh, your losses. Would your losses allow me to go to the 7.3? I don't find over here 7.3. on a fair reading.
Here there is no 7.3.
On a fair, paragraph 15. Paragraph 15 is equal to 7.3.
On a fair reading.
On a
yes.
fair reading. On a fair reading of Rule 16 of 2000 rules read with guidelines referred to above. Once the final selection list is prepared, there shall be no waiting list and post. If any unfilled for any reason whatsoever shall be kept. It's
Judge,
guided by
did
the
it.
specific
Judge, did it.
rules, man.
Judge, did it.
Yes.
That's malab the our case is that malab this judgment Vallapati was not applicable to our case.
That will be all.
That's malab all awesome.
2022 volume 13 SSC have got lots.
Yes, yes.
Vallapati.
Vallapati.
Yes, you have given us. Today is 20. It will come under orders, but we'll pass the file. For
addition of parties.
Whatever. That is not permissible. Until
not a
unless they are
party
made
before
part.
the tribunal.
No.
Then how can?
That application.
What has happened? Tribunal already decided the issue that
No,
we
no.
participate without any objection. That's why I filed.
That
We have participated without any objection. Without
that you have. Have you said in the OA that at any time you have objected to the terms of the advertisement? Then what is wrong?
That application may not be allowed.
No, that is an admitted position.
Right.
Before the High Court also in the earlier round you have said.
Absolutely, we have not challenged.
No, notification is not against us.
We are seeking benefit.
In fact,
No.
you are now, your case is that advertisement as it is, the intention is to have a provisional. That is what.
But in the can be state
No, we'll dispose of everything.
Can it?
Obliged.
Much obliged.
So all argument in all three cases complete.
Yes.
You give your appearance also in the sixth. Yes.
Obliged, madam.
Item number 1. Item 1.
Though the can 1 of 2023 was heard, but along with the application, written notes of argument were filed, and after going through the entirety, it is found that the matter is to, as there is a just cause, the matter is to be sent to the district judge concerned for revocation. So we are disposing the entire matter with the direction granting liberty to prefer before the learned district judge for revocation.
Deeply opposed.
So the entire thing is disposed of. Submission was made on the everything. We are disposing. Yes.
Deeply obliged.
Item number 50.
My lord, it has not been approved. My lord, may I then submit the notification I was referring about, that after all this, they have come out with a fresh notification, now onwards giving a cautionary? Or on the next date, as your lord? My lord, my lord, my lord, my lord, my lord, my lord. Huh? My lord, Monday 2 p.m. or Monday? I am grateful.
Monday is no matter is fixed.
Monday will
One matter. Then what about Tuesday? Tuesday? All Tuesday. Then.
Monday will be the monthly state.
All right, Tuesday.
I am grateful.
I'll look at it. I remember I sent it to you. So otherwise there's no change required. Some mistakes here. Minor. And we obtained all this.
Item number 8.
I am paying for the petition, my lord.
And I was the respondent in this matter.
There's a evidence of service, my lord. বেশ, স্যার আমাদের একটাই আছে।
দিয়েছে কি বলবো আর?
আপনি নিন কতক্ষণ একটা দেখুন, আমি ট্যাব দেখে বুঝছি, অসুবিধা নেই। আমি আপনাকে তো একটা জেরক্স কপি দিয়ে দেবো। My lord, if your lordship could remember, my lord. না না স্যার, ম্যাক্সিমাম 5 মিনিট। I am appealing for the petition, my lord. On the last occasion, if your lordship could recollect, my lord, this is that matter, my lord. It's a review, my lord. The scope of review is very much limited, my lord. But the difficulty was that whether I had the government certificate or not. On that basis, my writ petition was being disposed of. My lord, kindly takes the order, my lord, which is annexed to the memorandum of review, my lord. My lord, right now I have the copy of the medical certificate, my lord, which clearly indicates that I have a 75%. My lord, it is annexed to the memorandum of review, my lord. Yes, my lord. Sorry, 21st July 2015. In WPCT 125 of 2015. There is also one CAN application for condonation of delay, my lord. There is a 53 days delay in filing this review, my lord, which is still pending, my lord.
Yes, so why the review? What is wrong?
My lord, there is no wrong, my lord. Technically, my lord, just to could hear me just for 2 minutes, my lord. There is no wrong, my lord, as such. But my lord, on that point of time, there were some latches, my lord. I would candidly submit whether it's a part on the client's, my lord, or the advocate, my lord. I will not say that for on the part of the advocate, but as the person who has appeared earlier, my lord, it was not furnished, my lord. That is true, my lord. I cannot change my case, my lord. From the face of the order, I cannot change my case.
Neither
But
placed in the writ nor placed in the review.
yes, my lord, absolutely. But it has been placed right now in the, my lord, in the review petition, my lord. It is there, my lord. For appropriate orders, if your lordship would take up my can, my lord, I have placed the certificate, my lord. My lord could record my submission, and my lord could
Where is the
whatever
can?
my lord, it is 6584 of 2016. It will be can 2, my lord. The new number is can 2, my lord. It is annexed to the can 2, my lord. Page 24, my lord. Page 24 is the annexure, which, my lord, which is relevant annexure, relevant document, my lord.
Page 24.
24 of can 2, my lord. The old can number is 6584. Right.
Page 24.
একবার 24-26 একবার দেখে নে was passed on, my lord. একটু দেখুন yes, my lord. Page 65, my lord. 31st March 31st March 2015, my lord. Yes, my lord. My lord, there was a point, my lord, whether I have any government certificate or not. That was the only issue, my lord. And that is the certificate which I have showed earlier, my lord, page 24. That was the only point. Yes, my lord. In the review, we have annexed a private hospital, my lord, certificate, my lord. And that for reason we have came before the High Court. The writ was dismissed on that point only. Honorable Justice Nishita Matre, the then was, my lord, as asked that whether we were having the certificate on that point of time or not. But we were unable to produce that certificate, my lord. Yes, my lord. I will not, my lord, I will not say that I have mentioned. It has not been mentioned. It was not been mentioned, my lord. We have came up, my lord. Kindly, my lord, could record my submission at least, my lord. My lord, I will not. I know that, my lord, the scope of review is very much limited. I know. No, the respondents are appealing, my lord.
My lord, it is a close issue in 2012, my lord. The drive was, my lord, as introduced. item number legal. Item number legal also dark answer.
Obligement. Have tried my luck, my lord. Yes.
Item number 10.
No, my lord. Your lordship, kindly come to page 21. It's annexed to my lord the original application also. My lord, this is the advertisement, my lord. Last, his engagement was Trackman Engineering.
Yes,
Serial number 7.
yes.
Group D post. Now, next page. Written examination was, my lord, held on November 4, 2007. Thereafter, physical efficiency test was done on June 2nd, 2008. And lastly, medical examination was held on November 29, 2008.
Written on?
Written examination was held on 4th November 2007.
After that?
After that physical efficiency test, that was held on 8th June 2008.
Yes.
And thereafter, last medical examination was held on 29th November 2008.
Trackman Engineering.
Trackman Engineering. Now, my lord, this after these three parts being over, my lord, appointment could not be governed. There is a litigation which continued for some time. And next page, page 25, on 27th August 2012, the provisional appointment in the category of temporary trackman engineering.
Yes.
Was given. Now, after this, was given, next page 26. Next page 26. Have you looked, got 26, my lord. Right hand column last. he has accepted this post appointment. I accept an offer in terms of the detailed above on 27 September 2012. Have you lordship got?
Yes.
Thereafter, page 27, I have already provided my lord the legible copy. This is a later dated 18th October 2012. After acceptance of my lord the appointment. Dear my lord, the question of production of medical certificate. In the advertisement, there was no such mentioning. You may produce medical certificate in respect of Para 522(1) of IREM, Indian Railway Establishment Manual, within 1 month. From the date of receipt of the letter of evidence above the possibility of error of judgment in the decision of the medical authority, the certificate will not be taken into consideration unless it contains note of the medical practitioner concerned, the effect that he has been given full knowledge of the fact that the candidate has already been rejected.
As evidence above the possibility, it doesn't make any sense.
Yes, that is my learned friend my lord can explain. That is the language, exactly the language, my lord. I was also my lord.
That is not, sir. That is because your document is illegible. It says letter as evidence about the possibility of an error.
About. It should be.
No, it is the appearing to be ABOUT.
But my lord, he was directed to produce medical certificate. Next page, that was provided.
Yes.
He was, my lord, medically decategorized after appointment, my lord, in the category of B2, while, my lord, he was fit for C1.
He was decategorized as
B2, medically decategorized B2.
B2. When he was decategorized?
My lord, thereafter, my lord, I didn't find any document from neither from the affidavit also. But my lord, definitely, my lord, after my lord,
you have been decategorized and you don't know when you have been decategorized.
My lord, it's a document, my lord. Entire thing, my lord. Before the tribunal, I was not there. But my lord, what is there, my lord? I cannot improve otherwise. But and my lord, in the affidavit, my lord, that has also not been made clear and disclosed by the respondent. Now, my lord, in the prayer, my lord, that is my lord vital, my lord. Before the tribunal,
so instead of C1, you have been placed in B1.
B2, my lord, I was not fit. C1, I was fit. That is why I approached the tribunal with a prayer that is at page 19.
Page
19. 19. Though, my lord, my view is something different, even then, my lord, I cannot go beyond the prayer made before the tribunal. Prayer A.
You want to become a parcel porter.
Parcel porter. My lord, same category, group D, serial number 1. The advertisement that I was, my lord, I placed, my lord, serial 1, my lord, was parcel porter. Next page, just, my lord, next page at page 21. Sorry, my lord, I stand corrected. Serial number 3.
Yes.
So I sought appointment instead of, my lord, since, my lord, I was medically decategorized, I sought appointment alternatively as parcel porter, serial number 2, both are, my lord, group D. Now, my lord, the tribunal rejected.
It is not in dispute that you have been declared as C1.
B2, I was declared unfit, medical decategorized. And C1, my lord, I am eligible.
So that is not in dispute.
That they have not also disputed. Now the question is,
Yes.
now the question is here, though my lord that was not at all discussed by the tribunal also, whether I could be offered for alternative appointment when I was medically decategorized after being provisionally appointed. Now, my lord, the memo where, my lord, I was directed to bring the medical certificate, which was subsequently produced and not considered, 18th October 2012, there, my lord, the respondent, my lord, relied on a certain, my lord, para of Indian Railway Establishment Manual, IREM.
Yes.
Now, Indian Railway Establishment Manual, Rule 1305. Well, I've given a photocopy, my lord, also.
Sorry.
Now, my lord, it's an absorption of medically incapacitated staff in alternative employment. 1305. 1305. Alternative employment must be found in the case of permanent and temporary railway servant. My lord, he was temporarily appointed. Medically decategorized staff may, as far as possible, be absorbed in such alternative posts which should broadly be allied categories and where their background and experience in earlier posts could be utilized. There should be no difficulty in providing such alternative employment and no reversion of any officiating railway servant.
But this is for employees, those who are already employees.
No, no, no. At the bottom, top, my lord, alternative employment must be found in case of permanent and temporary
railway servant.
I have temporarily appointed. I have already given place, my lord, the appointment letter. That is at page 25.
Yes.
Offer for provisional appointment in the category of temporary trackman in engineering department. Now, this IREM has, my lord, statutory force. That has already been decided by the Honorable Supreme Court.
So when did you file your OA? What is the date of filing of the OA?
OA was filed in 2013.
2013.
Yes. Appointment was given in October 2012.
No, August 2012.
Sorry, August 2012. In October 2012, I was directed to produce medical certificate. Rejection was done. Immediately thereafter, my lord, I filed this way.
Where is the rejection?
Rejection order, my lord, that was, my lord, also, my lord. But that is admitted position. They have not considered me.
No, where were you asked to produce the certificate?
Yes. That, my lord, 18th October 2012.
Which page?
That is at page illegible copy, my lord, page
Acha,
27.
That one paragraph.
So, my lord, if IREM is a statute,
Yes.
it is binding upon them also, my lord, to follow. It is, my lord, up to them, my lord, to, my lord, clarify as to whether they will not follow their own rule.
Oh, but you have abandoned your claim against that post altogether. Where is the question of them responding? Something which you don't seek, how they will respond? You want appointment under the C1 category.
No, alternative appointment.
Yes.
That is exactly there, my lord, 1305.
Yes.
I cannot go. I something different was there in my mind, but I cannot go beyond the
18/10/2012. What did you do after this?
My lord.
After this letter they sent you on 18/10/2012. What
Yes.
did you do?
In 2013, my lord, OA filed. Immediately within few months.
They allowed you to produce medical certificate.
Yes. Next page. Page 28.
You produce the medical certificate.
Yes, it is a medical certificate.
How this can be a medical certificate?
Yes, my lord. It's my lord. My lord. Medical difficulty. My lord.
This is a prescription. This is not a certificate.
No, it was shown. It was shown to the doctor. It was shown to the doctor. It's a doctor certificate, my lord. It's a, my lord.
It's not a certificate. It is a prescription.
Prescription, my lord.
It is not certifying anything. It is just an examination and prescription. This is not a certificate. This cannot by any stretch of imagination be called a certificate.
But my lord, even my lord, my lord would not have, my lord,
never produced any certificate.
I would not have produced this one. My lord, my rejection was my lord. Result would not have been otherwise.
We don't know. This is of 2812. Whether you have produced it and whether it is.
But affidavit file, my lord, is not disclosing all these facts, my lord.
And plus, it does not give that disclosure which is required. So this is not reliable at all. IREM requires that the certificate should give a disclosure. Even that disclosure is not there. This is not reliable.
No, in order to support my category of temporary trackman, I was required to produce this medical certificate.
Yes.
I could not produce. My lord, for the sake of argument, my lord, say, my lord, I could not produce. That's why they did not consider me. But they also did not consider 1305 also.
But then
once I have been,
they have allowed you an opportunity to substantiate your claim for trackman engineering. You did not. Then did you ask them that give me a post on the decategorized category?
Well, by full submission, my lord, if the rule provides, my lord, it is up to them, my lord, to act on the basis of the rule, their own rule.
All right.
And my lord, whether, my lord, of course, my lord, it should have been made a part of the original application. But my lord, in the affidavit filed by them, this was not controverted.
What was not controverted?
This, my lord, this fact that that I could not produce any medical certificate.
Why should they controvert that?
Because it is their mandate to produce it. It was the basis of my rejection of employment under trackman engineering.
No, perhaps I'm not able to appreciate what you are saying. You say that they did not deny the fact that you could not produce a medical certificate.
Yes.
So why are they obliged to deny that you did not produce? You are not yourself. You have admitted that you did not produce.
The document which was, my lord, at the outset, my lord, I submitted, my lord, I cannot improve the case.
Therefore, we are saying
this is, my lord, the document that is at page 28.
You did not produce anything.
That is at page 28. Lordship is absolutely correct, my lord, for the timing, my lord, for the sake of, my lord, acceptance, my lord. It is not a certificate.
Yes.
My lord, even, my lord, they should have, since, my lord, they have required this document, they should have come forward and say, no, we are not going to accept this document. This is not a certificate.
It's not your case. You have abandoned that claim altogether.
Yes, I'm abandoned.
Now you are on whether I produced or not. Give me C1.
No.
Now, how do we go to C1?
No.
Where is the basis of going to C1?
When, my lord, I was not, my lord, considered in a particular category.
Yes.
Whether, my lord, even in alternate category is there.
We don't know whether they have to go immediately without your making any claim, whether there is any requirement in the advertisement. And this, whether this 1305 will apply, those things.
And my lord, in that event, my lord, I have to submit, my lord.
Yes.
In the advertisement itself, my lord, it was not specified
You
that
are not a staff. You could not join.
I accepted. I have shown.
You have. When did you join? What is the date of joining? Where have you given the date of joining?
Then I have to take instruction.
You have not joined, sir. You have been offered an appointment subject.
And I accepted.
You could not accept because you could not fulfill the certificate.
Yes, I accepted. On 27 September 2018.
Even if you accepted, unless you are an existing staff, this 1305 will not apply to you.
No, temporary appointment.
Where is that joining on the temporary post? Show us. That's what we are asking. You must have pleaded in the OA that after this appointment letter, I joined on such and such date.
My lord,
is there any joining?
Let
us see, where is the OA?
OA is, my lord, starting from page 12.
Yes. So what have you said about joining? Let us see.
At page 16, 4.3, 4.4.
No, there is nothing.
No
joining whatsoever.
There's no. But my lord,
that when I was not appointed, I asked them to give me a lower category.
My lord,
so how you are invoking 1305? When the facts are not pleaded, how can you invoke 1305?
My selection process was over the moment, my lord, I medical examination, I fit.
Yes, you failed. They did not offer you any appointment.
I was.
You see what you have said. Come to page 16. Para 4.4. Please read it.
Applicant was sent, my lord, 4.3.
Yes, you read from 4.3.
My lord, the applicant was provisionally empaneled. An offer of provisional appointment in the category was sent to the applicant.
Correct. Now come to the next paragraph.
The applicant was sent for medical test.
Yes.
He was declared medically unfit in B2 category, wide medical memo. The applicant was declared medically unfit for the post of Trackman Engineering Department, medical category in B2. Now,
there is no joining. You never became a temporary or a permanent staff. You were offered, you were empaneled, but you could not succeed.
My written examination was conducted. I was found eligible. Thereafter, my physical efficiency, I passed. Thereafter, medical test, my lord, came out successful. Thereafter, a gap of 4 years.
Medical test, you failed, sir.
No, not that. Lordship, kindly come to page 28.
You come to page 16 of your pleadings. No, come to para 4.4. What do you say?
I'm coming.
What is your client said?
Lordship,
just read it, sir.
Lordship, allow me only one document.
We'll go to document after the pleading. The document will support the pleading, not otherwise.
No.
What is para 4.4 of your pleading?
That is not a subsequent part of medical decategorization.
No. Please read para 4.4. The applicant was sent to the medical test. He was declared medically unfit. You were never declared fit. You never joined.
May I submit one thing?
Lordship,
kindly come to page 24. Kindly come to page 24.
Yes, what is that page 24?
Letter for medical examination. That was held on 29 November 2008.
Yes, maybe.
Thereafter, provisional appointment was. Had I been, my lord, failed in the medical, appointment would not have been given. Page 24
of this
writ petition, my lord.
Yes. What is the date? Page 24.
24. Left hand column, my lord, date 29/11/2008.
24/11/2000.
29, I believe.
Yes.
29/11/2008.
Yes.
That date when I was sent for medical examination. I passed.
That is the date on which you were declared unfit.
No, thereafter provisional appointment given in the year 2012.
Correct.
After had I been declared unfit, appointment letter do not have been given.
Where is the appointment letter is at page
25. Next page.
25.
Next page. 2012, I was given appointment after successfully completed the medical examination. Thereafter, I was sent for further medical examination. When I was medically decategorized.
Just see the dates, sir.
And this medical examination is available only with the employee of the railway.
Where is the date of medical examination?
2008.
No, sir, it is not.
29/11/2008.
No.
Page 24.
You come to the bottom of that document.
Yes, 24/11. No, it was issued. And this was my pass was issued. Journey should be commenced from 24 November 2008 and should be completed within 3rd December 2008. And in the meantime, medical examination was conducted on 29/11/2008. On the basis of this medical examination,
but your pleading is otherwise. We don't know.
Pleading, my lord, lordship,
that's not supporting this document.
Medical subsequent medical examination is
no, that is not apparent from your facts.
Let that be controverted. Whatever I am saying, which is absolutely incorrect. First part of medical
it may be, you have never claimed that post. You have never claimed that post. Therefore, now there is no question now at this belated stage to now reopen this thing.
No, my lord, I approached the tribunal, my lord, within time, my lord.
We have seen that.
Medical decategorization is, my lord, available only with the, my lord, the employee of the railways.
Yes.
Second medical examination is not available, my lord, for the outsider.
Correct. That's what we are also saying. That's exactly what we are saying.
So 29 November medical examination was conducted. Thereafter, on 27th August 2012, I was given appointment.
Major discrepancy in the pleading and the document. It's very how you have
Pleading,
not,
my lord,
4.4. Make out a case. Where is the question of asking them to reply? Therefore, we are repeatedly asking you, how do you reconcile this? It does not reconcile.
4.3. A provisional appointment was mentioned.
Oh, not appointment, provisional empanelment for appointment. There's no question of appointment. Read what you have said. He was empaneled, not appointed. That's what you have said because you know what happened.
It was not happily drafted.
No, because you know what happened.
No, their document will speak for itself. Their offer for provisional appointment.
Yes.
Not empanelment. Offer for provisional appointment in the
applicant was provisionally empaneled. An offer for provisional appointment in the category was sent to him. Thereafter, he was asked to go for medical test where he was declared unfit.
No.
This is the exact pleading that we have.
Pleading, my lordship. Pleading, my lordship. It was not happily drafted. It was not happily drafted, my lordship. Kindly, my lord, kindly consider this aspect of the matter, but kindly consider, my lord, their own document. It is a document of mine, my lord. I have not created this document. There says, my lord, offer for provisional appointment in the category of. So that was done after 4 years. It's not that it was done hurriedly. In the meantime, some litigation was done. That's why it was kept pending. On the basis of the medical examination that was held on 29 November 2008, I was given appointment in the year 2012. And second set of medical examination is available only with the
tribunal. They did not file any reply.
No. It was, my lord, as many as, my lord, 18 cases were, my lord, considered and common judgment was delivered.
There is no averment regarding your joining. Therefore, nothing can be done.
You
are not a
joining. Joining.
Never joined. There's no question of applying 1305.
No, joining. My lord, next, my lord, second. I'm sorry for repeating, my lord. Second, my lord, state of medical examination is not available for the outsider, my lord, who was not even appointed. They are, my lord, available only for the persons who are temporarily appointed. That is exactly, my lord, 1305 is saying.
Yes. So where is the second medical examination? In your case?
My lord, September.
After 27/8/2000.
Yes.
Where is the second medical examination?
That is their document, my lord. I cannot.
You must have gone to the for being medically examined. You have not said that there is any medical examination, second medical examination for decategorization.
That was exactly, that was my lord, pleaded in paragraph 4.4. After appointment 4.3, appointment was dealt with. 4.4 dealt with. After appointment, he was sent for medical examination.
There is no appointment, sir. You are reading something which is totally absent from your pleading.
I'm not kindly.
You are trying to read something which is not there, which
It's a
we will
poor
not.
person, my lord. Kindly, my lord, kindly, consider, my lord. His fate is with your lordship, my lord. But my lord, the document says something.
There is no such thing. There is
I'm
only,
not.
There is only one medical examination. There is no second medical examination.
No. Had my lord he been, my lord, disqualified, 27th August 12th, my lord would not have arisen. Let them produce record.
In the 27/8/2012, does it say anything about a prior medical examination?
Normally, my lord, appointment letter, my lord, these things are not said.
Nothing, sir. Sorry. Can't be done.
Only with regard to acceptance. Paragraph 11, there is a acceptance of this. My lord, whether I was, my lord, physically fit.
Nothing can.
My lord, well, at least, my lord, record be produced. At least, my lord, record be produced.
Not
record will, my lord, reveal everything.
Your pleading does not make.
Pleading, I'm not, my lord.
We will go by that. You may not as a lawyer. We will go by
my
the
lord, I'm not also, my lord, happy with the pleading.
It's not a question of happy. There is no pleading whatsoever. There may be a vagueness that we may attribute, we may allow to be interpreted either way. There's no, it is a specific assertion.
But my lord,
your prayer is also not for that.
But my lord, the document, my lord, 27th August 2012.
We'll consider that document. We'll consider that document. Don't worry. Yes, I heard the learned counsel for the petitioner, CAB. Yes, tell us. Sorry, we should have allowed.
Okay.
Yes.
Lordship, there is a very important point that there is no scope of alternative appointment as my learned friend is praying for, because there is a railroad order which has been set out in the impugn order of the central
of the tribunal.
Yes, Lordship.
Consider that.
And on that basis, Honorable Supreme Court also passed a judgment. That is, if your Lordship kindly allow me.
Yes.
Lordship, kindly see page 4 of the last paragraph of the impugn order. And copy of the railway board order.
My lord, they have not disclosed in the affidavit. That has not been dealt with in the affidavit.
Then we'll consider. Same CAB.
Very much mentioned in page 8.
All right, we'll consider.
And my lord, I'm relying only one paragraph of a judgment, my lord, where my lord Supreme Court says, my lord, IREM is a, my lord, has got a.
There is no dispute on that. Where's the dispute? There's not an issue. Whether it applies to you or not, that is the issue. Not with the enforceability or the from the earlier. Earlier case.
Item number 11.
11, my lord, I am for the petitioner, my lord. I am paying for not this week, my lord.
Not this week,
Not this week.
as prayed, just after a week.
Item number 12.
Well, my lord, I am for the petitioner in this matter.
Senior.
Last
Praise the
appeal
Lord.
will have to be
In this
regarding the
regard,
lawsuit
Lord,
direct-
I taking instruction from Department, Panchayat and Rural Development, Government of West Bengal. Some take a time, your lordship kindly extend.
This is
the
very
instruction.
old matter.
Yes, your lordship. Very old matter.
And last
Just
appeal, my senior already has withdrawal of the only law point is involved. Anyway, they prayed for 10 to 5 their affidavit, but till now no affidavit and opposition has been filed. Now your lordship decided.
Yes, you proceed. We have given you last indulgence already. We have to proceed. Yes. You
I'm-
proceed.
I shall place the matter.
Yes.
First thing that I'm placing the judgment of the tribunal because tribunal without and inviting any reply opposition dismissed by application on the plea that we are not just a state officer.
You are not the
We are not the state post holder. We are the
state post holder.
I am claiming that I am the state government employee. That is my submission. Lord. First, Lord, I am placing that is a list of dates.
No, what is the date of the order passed by the tribunal?
On page 5,
Judgment.
152. Lord. Can you see page 152?
You are not given certified copy.
Yes, Lord. Usually when we file it, page 226.
The repetition.
I have got it.
Without the certified copy, why the certified copy?
Because without certificate copy, department cannot accept it.
In between, she has annexed the certified copy. Now, the certified copy, just it should be at the last. That's what I'm saying. I don't know how the stamp is.
Now, Lord, I'm placing the judgment. Lord. Can you see this? That is dated 1st August 2019. Video service filed on behalf of the applicant, 2 days kept on record, Bogalatanga file, that applicants have prayed for direction upon the respondents for grant of benefit of career advance scheme and for deposit of provident fund as government employees. The applicants were appointed by the Commissioner, Panchayat and Rural Development, Government of West Bengal for the post of Assistant Coordinator for Jila Parishad belonging to the State Panchayat cadre under the Department of Panchayats and Rural Development, West Bengal. The Commissioner, Directorate of Panchayat and Rural Development, Government of West Bengal has clarified the status of the applicants for the purpose of grant of benefit of career advancement scheme in memorandum dated 1st February 2019. It appears from the said memorandum dated 1st February 2019 that the applicants are holding non-government posts in the state Panchayat cadre under Jila Parishad in the Department of Panchayat and Rural Development, Government of West Bengal. The said memorandum dated 1st February 2019 lays down that the applicants holding the post of Assistant Coordinator of Jila Parishad are entitled to get the benefit of career advancement scheme for completion of satisfactory 10 years service and 20 years as the employees of the Jila Parishad. And as such, the question of granting benefit of career advancement scheme to the applicants on the completion of satisfactory service of 8 years does not arise. With regard to deposit of the subscription in the Provident Fund of the applicants, it is clarified in the said memorandum dated 1st February 2019 that there is no provision for opening of General Provident Fund account in case of Jila Parishad employee, like the applicants in the office of the Principal Accountant General, AE and West Bengal. And as such, the account of the Provident Fund of the applicants is maintained by the accounts officer in the Jila Parishad, having heard learned counsel for the applicants and learned counsel for the respondents. We are of the view that the applicants are not holding the civil post under the state, and as such, we do not have the jurisdiction to entertain the present application for grant of relief paid by the applicants. The original applicants is clearly barred by under section 15. This is the observation of the tribunal, my lord. Now, my lord, I am placing the facts, my lord. My lord, kindly see next page. Post creation memo. I am claiming that we are the holding the post of this under the government of West Bengal. Next page, 156. 2nd February 2006. Shishu Shiksha Karmoshuchi was launched in order to supplement the efforts of the school education department to universalize primary education in the state. Subsequently, Madhyamik Shiksha Karmoshuchi was also launched for the upper primary level. While the Panchayats and Rural Development Department implements the program through the Paschim Banga Rajya Shishu Shiksha Mission at the state level, this Karmoshuchi are coordinated and supervised by the Jila Parishad in the district level. For this purpose, Jila Parishad have to depend on a part-time officer and employees besides a district coordinator who is the only whole-time employee. It has been felt that the present arrangement of supervision and coordination at the district level is too inadequate, and the availability of the service of a whole-time officer having exposure in the field of education is necessary. Besides that, it is also considered necessary to have a whole-time assistant who would provide the secretarial support, handle the information systems, prepare periodical reports, and maintain data, etc. regarding these Karmoshuchis. After careful consideration of all these aspects, the governor is hereby pleased to create the following post for the Jila Parishad and the Shiliguri Mahokuma Parishad, not under the for the Jila Parishad. Total 25 posts of assistant coordinator in the scale of pay such and such, and total 18 posts. That is not.
What is the date of this document?
That is the 2nd February 2006 post creation memo issued by the governor, principal secretary by the order of the governor. Thereafter, Lord.
Which page you are reading?
That is page 156. After judgment, my lord. So 25 posts of the assistant coordinators were created for the Jila Parishad. 2002, 2000.
So when the rules came into force?
Later on, my lord.
What is the date? Where is the rule?
Yes, my lord. Rules coming on. Yes, my lord. Initially gazette notification, that is 1997. At that moment, that is assistant coordinator post was not there. Thereafter,
No, this
yes, but I am coming.
post was created on 2nd February 2006.
Subsequently, rules has been framed.
Must be before your appointment was made.
No, here's the fact is different because initially they given the appointment. Thereafter, they frame. I am coming, my lord, one after another. Then my lord, the entire picture will be clear, my lord. So, my lord, when the rules has post creation, after creation of the post,
Where is the advertisement leading to your
that
appointment?
is page 158. Page 158, my lord. In Bengali, পঞ্চায়েতের গ্রামোন্নয়ন দপ্তরের পক্ষ থেকে শিলিগুড়ি মহকুমা পরিষদ ও জেলা পরিষদগুলিতে
Can I understand it? Can you understand? Is there any reference to rule in the advertisement?
No, at present there was no reference. Subsequently, it has come. That's why I'm coming.
After your
Thereafter-
appointment?
After appointment. After appointment. Kindly see the next page, page 161. That is 18 May 2007. The state government in the Panchayat and Rural Development Department has been considering for some time past the matter of constitution of cadre of, well, got it the page?
Yes, we have got.
Constitution of the cadre of officials for 3 tiers of Panchayat Raj institution. The West Bengal Panchayat Second Amendment Act 2006, West Bengal Act 2, 2006 has been enacted, and the executive officer of Panchayat Samiti has been made appointing authority for the Gram Panchayat Kodmis within the jurisdiction of the concerned block, whereas the executive officer of a Jila Parishad has been made appointing authority in respect of all other employees of a Gram Panchayat. And all the employees of a Panchayat Samiti as well as the Jila Parishad within the jurisdiction of the concerned district. After careful consideration of all aspects, the matter, the governor in exercise of the power conferred under section 212 of the West Bengal Panchayat Act, can after referred to the said is pleased hereby to direct that the Gram Panchayat be appointed to Gram Panchayats within a block under subsection 1 of the section 35 of the said Act shall form block Panchayat cadre. B, Lord, other employees of the Gram Panchayat appointed under subsection 2 of section 35 of the said Act within a district shall form the district Panchayat cadre for respective post. C, Lord, employees appointed to Panchayat Samitis within the district under subsection 2 of section 119 shall constitute district Panchayat cadres for respective post. And D, Lord, in a Jila Parishad employees appointed under subsection 3 of section 166 shall constitute district Panchayat cadres for respective post. Now, Lord, we are following in the game, Lord, clause E. For appointment of officers to Jila Parishad under subsection 2 of section 166, there shall be 2 sets of officers, namely 1 officers deputed to Jila Parishad from constitute state services or all India services. And Roman 2, Lord, officers appointed for services to the Jila Parishad only the officers as mentioned at serial number 2, serial 2, Roman 2 shall belong to state Panchayat cadres for respective post. So, my lord, we are the next, my lord. The governor is further pleased to declare that appointing authority for the officers belonging to state Panchayat cadres, as mentioned at serial 2 of para E, shall be the Commissioner of Panchayats and Rural Development, West Bengal, for the purpose of supervising the Shishu Shiksha, Karmoshuchi and Madhyamik Shiksha, Karmoshuchi, and also for undertaking different activities relating to such program. The state government in the first Panchayat and Rural Development shall appoint. So let state government shall appoint to the an assistant coordinator for each Jila Parishad, Mahakuma Parishad, and the post of assistant coordinator shall belong to the state Panchayat cadre. The officers belong to state Panchayat cadre may be transferred to any Jila Parishad, Mahakuma Parishad within the state at any time of the administrative ground by the Panchayat and Rural Development Department. So, my humble submission before the Lord says, here is the appointing authority, state government. Now, next, Lord. Thereafter, interview was held, and we got the appointment. That is, verification role has been. Now, Lord, kindly see that is the appointment letter. one of the appointment letter I have in annex, that is 29 January 2008, page 164.
Yes, we have seen that is for 6 months.
Yes. So, my lord, our
Where is the order of 17/8/2009? Annexure O of the OA. Where is Annexure O of the OA?
2009.
Annexure O of the OA.
Now, just now your lordship asked me that the rules regarding the appointment. That is page 103. 13 July 2009 rules was framed. That is notification was issued. Panchayat and Rural Development Department, in excess of the power conferred by section 224 with section such and such, the governor is pleased hereby to make, after previous publication as required by subsection 1 of the section, the following amendment to the West Bengal Panchayat's recruitment condition and appointment of Jila Parishad rules.
You are not treated as government employees.
Yes, ma'am.
You are not being treated as government employees.
That's why my challenge is we have to be treated as government employees.
Yeah.
Because our appointing authority is the commissioner. Kindly that you see these rules. Just now I placed it. That is 103.
You have sought quashing of 2 orders. Where are the 2 orders? 17/8/2009 and 1/2/2019. Where are these 2 orders?
1st February 2009.
No, 17th August 2009.
Yes. Page 188.
188.
Yes. P14. Issued by the Principal Secretary. I am directed to say that since the issuance of this department memo number 13 July 2009 framing recruitment rules for the post of Assistant Coordinator, since renamed as Assistant Coordinator, Education in Jila Parishad, Siliguri Mahakuma Parishad, some points relating to the post and services status have been raised by different Jila Parishads. On examination of all points, a clarificatory statement is given as below. His clarification, the post is a non-government post born in the state Panchayat cadre under the Jila Parishad, Siliguri Mahakuma Parishad. Appointing authority is the Commissioner, Panchayat and Rural Development, West Bengal. Controlling authority is the Commissioner. Service of Assistant Coordinator Education are transferable inter Jila Parishad. ACR of the Assistant Coordinator Education shall be initiated by AEO and Jila Parishad SMP. In the matter of leave, PF and pension, the extent norms, the procedure being followed in the case of other employees of the Jila Parishad. It is under challenge. Thereafter, I am challenging already. That is next page 191. 1st February 2019. When the petitioner claimed for cash benefit after completing the 8 years, the authority denied it on the ground. Page 191. Issued by the Commissioner.
190.
91. 1st February, this is under challenge. Issued by the 1st February 2019 by the Commissioner to the Additional Executive Officer. Subject cash benefit and opening of GPF account in respect of employees of Jila Parishad, Siliguri Mahakuma Parishad. Apropos the subject as clarification in file noting such and such of the Panchayat and Rural Development Department, West Bengal, the following points are being stated for taking further necessary action in respect of employees concerned. These also has a reference to the petition dated 1st November 2007 of Sri Devobrata Bishwas and Devojyoti Das, both Assistant Coordinator Education. The post of Assistant Coordinator Education is a non-government post in the state Panchayat cadre under Jila Parishad. But my lord, initially the principal secretary stated that the appointing authority is the state. Now the principal secretary commissioner is stating that no assistant coordinator is a non-government post in the state panchayat cadre under Jila Parishad.
No,
per
from
seven-
in the rule also it has been said that this is under the panchayat cadre. This is not under in the rule also. The rule that you have read, 2009 rules.
2009 rules, that is
Also
the
it
appointing
says-
authority is the commissioner.
Yes, but in
And
the
Jila
panchayat
Parishad-
cadre,
Jila Parishad employees are
this officer belongs to the state panchayat cadre.
cadre.
Yes.
So my lord, on that point, not only that, appointing authority,
So
disciplinary
what is the
authority.
state panchayat cadre? Where is the state panchayat cadre defined? Where is it?
Just now I have placed it, that is
Lordship, kindly page 117.
117.
117, 29 January 2008, your Lordship's order passed by the Panchayat and Rural Development District. Appointment purely provisional only for
No,
6
no,
months.
where is the cadre? Where is the state panchayat cadre?
This is the appointment.
No, no, where is, there must be a cadre rules. It says it shall belong to the state panchayat cadre, your post. Assistant coordinator.
No,
Can you see the post creation memo?
That we are seeing, madam, that is why we are asking you. After seeing that only we are asking you.
Because they have stated, I'm coming, blood, I'm coming.
ট্রাইব্যুনাল জুরিডিকশন যেটা বলে সেটা কোথায় সেটা দেখিয়েছে না দেখায়নি তাহলে যে সব দেখুন
That is page 161, my lord. My understanding it will be your lordship's query. That is 18 May 2007.
Correct. So next page 162, you please see, that is what we are reading.
Yes, the state government in the that is governor is further pleased to declare that appointing authority for the officers belonging to the state panchayat cadre, as mentioned at serial 2.
Shall be the commissioner of the Panchayat and Rural Development.
Yes.
For the purpose of supervising Shishu Shiksha Karma Suchi and Madhyamik Shiksha Karma Suchi, and also for undertaking different activities related. The state government in the Panchayat and Rural Development shall appoint an assistant coordinator for each Jila Parishad, and the post shall belong to the state Panchayat cadre.
Yes.
So where is this cadre? What is the terms and conditions? That is why we are asking you, where is this cadre?
Because tribunal did not decide anything and government, they have not also
where is
disclosed
the-
anything.
Government has already, you please see page 191. Or even before that.
191, my lord. That is 1st February 2019.
Sorry.
But kindly see the next page.
17/8/2009 at page 188.
188.
Yes.
Yes.
Post is a non-government post.
That is the version of the principal secretary.
Born in the state panchayat cadre under the Zila Parishad. So therefore, what is this cadre? That's what we want to see. How they are drawing the distinction that all those who are born in this cadre, they are not state government employees. Where is that cadre rules? Where is the structure of the cadre? Where is the state panchayat cadre, Mr. Mukherjee?
State Panchayat cadre, but this is under Department of Commissioner of Panchayat.
Where is that? Can we see it?
10 days time, but I'll bring that. Or 10 days time may be given.
Now we are not going to allow you to file opposition. Just show the cadre, because last indulgence we have given. We cannot extend. Show us the cadre. Yes.
Cadre strength.
Yes.
Whether the